Next page. Chapter 1, The Companies Act, 2008 and Corporate Law Reform. 1.1 The Companies Act, 2008, A New Approach. South Africa has had 3 Companies Acts, 1926, 1973, and the current Companies Act, 2008, which commenced on May 1, 2011. The Companies Act, 1973 was frequently amended to stay relevant. For example, Companies Amendment Act allowed companies to buy back their own shares. Another amendment allowed close corporations to convert into companies. Despite amendments, a new act was necessary due to political changes post-1994 and the adoption of the 1996 Constitution. Global corporate law trends, requiring modernization for international business. Corporate governance concerns, ensuring accountability and stakeholder rights. Encouragement of foreign investment through a legal framework aligning with global standards. Comparison with UK, Australian, and New Zealand company law reforms. Judicial interpretation shift. Courts are required to align corporate law with constitutional principles and modern corporate governance. Nedbank Limited v Bestvist 153, Proprietary, Limited. Key purposes, S7. Encouraging business activity and entrepreneurship with flexible regulation. Balancing corporate growth with accountability. Recognizing stakeholders' interests beyond shareholders. Simplifying company formation. Introducing business rescue provisions to replace outdated judicial management. Shifting from capital maintenance to liquidity and solvency as key principles. 1.2 The Close Corporations Act, 1984. Enacted alongside the Companies Act, 1973. Introducing the Close Corporation. Designed for small businesses with simple incorporation. Membership limited to 10 natural persons, no corporate members. No restrictions on business size, turnover, or employees. Avoided complex legal doctrines, for example ultra vires doctrine, capital maintenance. Companies Act, 2008 Impact. Existing close corporations, as of May 1, 2011, may continue indefinitely. No new close corporations may be formed after this date. The Close Corporations Act remains in force, with certain Companies Act, 2008 provisions, for example business rescue, applying. Case law, J&K Timbers, Proprietary, Limited VGL and S Furniture Enterprises CC. Every member of a close corporation acts as an agent for the corporation. Binding contracts can be made by any member without other members' consent. 1.3 Background to the Companies Act, 2008. 1.3.1 2004 Policy Paper, Guidelines for Corporate Law Reform. Released by the Department of Trade and Industry, DTI. Outlined the need for a modern, efficient, and cost-effective company law framework. 1.3.2 The National Economic Development and Labor Council, NEDLAC, consulted during corporate law reform. Emphasized stakeholder inclusion and economic development. 1.3.3 Corporate law reform and the stakeholder question. The Companies Act, 1973 mainly protected shareholders. The 2008 Act acknowledges broader stakeholder interests, for example, employees, trade unions, minority shareholders. 1.3.4 Enlightened shareholder approach in the Companies Act, 2008. Shareholders' interests remain primary, but directors must also consider stakeholders. Aligns with international trends, balancing profit-making with social responsibility. 1.4 Purpose and interpretation of the Companies Act, 2008. 1.4.1 Purposes of the Act, S7, promotes economic growth and investment, efficient and flexible company law, corporate accountability, stakeholder interests, beyond shareholders, business rescue and financial stability. 1.4.2 Interpretation of the Act, S5 Read with S7, courts must interpret the Act in line with the Constitution, considering international corporate law trends. 1.5 Flexibility and the importance of the Memorandum of Incorporation. The Memorandum of Incorporation, MOI, allows for company-specific governance rules, provides flexibility while maintaining statutory compliance. 1.6 Structure of the Companies Act, 2008. Chapter 1, Interpretation, Purpose, and Application, SS 1-10. Chapter 2, Formation, Administration, and Dissolution, SS 11-83. Chapter 3, Enhanced Accountability and Transparency, SS 84-94. Chapter 4, Public Offerings of Securities, SS 95-111. Chapter 5, Fundamental Transactions, Takeovers, and Offers, SS 112 to 127. Chapter 6, Business Rescue and Creditor Compromise, SS 128 to 155. Chapter 7, Remedies and Enforcement, SS 156 to 184. Chapter 8, Regulatory Agencies and Administration, SS 185 to 212. Chapter 9, Offenses and Miscellaneous Provisions, SS 213 to 225. 1.7 Key Concepts and Features of the Companies Act, 2008. Simplified Company Incorporation and Administration. Business Rescue Provisions replacing Judicial Management. Solvency and Liquidity Test replacing Capital Maintenance. Stakeholder-Oriented Governance Model. 1.8 Types of Companies. Profit Companies. Private Companies, Proprietary, Limited. Public Companies, Limited. Personal Liability Companies, Incorporated. State-Owned Companies, SOC Limited. Non-Profit Companies, NPC. 1.9 The Companies Act, 2008 and the Common Law. 1.9.1 When the Act is silent, common law applies. Courts can apply common law principles unless contradicted by the Act. 1.9.2 Common law principles continue unless abolished or modified. Some common law rules remain unless explicitly changed by the Act. 1.9.3 Companies Act supplements and expands common law. Statutory provisions expand upon common law principles where necessary. 1.9.4 Common law principles abolished in some cases. The Act abolishes certain common law doctrines, for example, capital maintenance rule replaced by solvency and liquidity test. _ These notes provide a detailed yet concise summary of Chapter 1 of the Companies Act, 2008, including key legislative provisions, case law, and corporate governance principles. Let me know if you need any further refinements. Next. Page 1.3 Background to the Companies Act, 2008. The drafting of the Companies Act, 2008 involved various processes, forums, discussions, and stakeholders. Key influences. 2004 policy paper by the Department of Trade and Industry, DTI. Agreements reached at NEDLAC, National Economic Development and Labor Council. Trade union pressure to expand stakeholder rights in company law. 1.3.1 The Department of Trade and Industry's 2004 policy paper, Guidelines for Corporate Law Reform. Title, South African Company Law for the 21st Century, Guidelines for Corporate Law Reform, 2004. Main objectives. Facilitate a predictable and consistent regulatory environment. Promote competitiveness and economic development. Encourage entrepreneurship and enterprise growth. Simplify company formation procedures and reduce costs. Promote investment and innovation in South African markets. Provide flexibility in company design and organization. Improve efficiency, transparency, and corporate governance. Preserving common law. The Act does not codify all aspects of company law but incorporates key common law principles. Some common law doctrines were abolished, for example, common law derivative action replaced by statutory derivative action under S-165. Goal. Ensure legislation aligns with South Africa's constitutional democracy and open economy. The reform process moved to NEDLAC negotiations between government, business, and labor. 1.3.2 The National Economic Development and Labor Council, NEDLAC. NEDLAC provides a forum for business, labor, and government to negotiate social and economic policies. Company law reform was included within its mandate. 5 key corporate law reform objectives were agreed upon at NEDLAC, see Table 1.1. This summary extracts the key points while maintaining detail. Let me know if you need any modifications. Next. Page 1.3.2 Corporate law reform objectives agreed at NEDLAC, Table 1.11. Simplification, reducing company formation and maintenance costs. Introduce company structures similar to closed corporations as an option. Create a simple, maintainable regime for nonprofit companies. Cooperatives and partnerships should not be included in the reformed company law. 2. Flexibility, allowing diverse corporate structures. Ensure varied corporate structures are available. Maintain distinction between listed and unlisted companies. 3. Corporate efficiency, enhancing company management and operation. Shift from capital maintenance, par value system, to a solvency and liquidity-based system. Clarify board structures, director responsibilities, duties, and liabilities. Provide a remedy for minority shareholders stuck in inefficient companies. Reform the mergers and takeovers regime to facilitate business combinations. Replace judicial management with a more effective business rescue system. 4. Transparency, strengthening corporate governance. Recognize director accountability and stakeholder participation. Impose truth and accuracy standards for public announcements and prospectuses. Strengthen shareholder rights, activism, and minority shareholder protections. Require minimum accounting standards for annual reports. 5. Predictable regulations, aligning with international best practices. Decriminalize company law sanctions where possible. Reduce regulatory arbitrage opportunities. Ensure enforcement through appropriate regulatory bodies. Balance adequate disclosure for transparency with avoiding overregulation. Let me know if you need further refinements. Next page. Corporate efficiency, capital maintenance versus solvency and liquidity. 1. Capital maintenance rule, historical approach, established over a century ago to protect creditors by ensuring share capital remains a permanent fund. Prevented companies from returning share capital to shareholders unless specifically allowed by legislation or common law. Case law, Cohen v. Siegel, share capital cannot be returned to members as it forms part of the fund that creditors rely on for payment. 2. Prohibitions under the capital maintenance rule. No share buybacks. Companies were prohibited from purchasing their own shares. No dividends from capital. Dividends could only be declared from profits. No financial assistance. Companies could not provide financial assistance for the purchase of their own shares. 3. Solvency and liquidity regime, Companies Act, 2008, abandons the capital maintenance rule. Solvency and liquidity test must be met before any capital distribution to shareholders. SS 44-48 of the Act ensures financial stability while providing flexibility for corporate restructuring. Next page. Here's a condensed and structured version of your notes. Underscore 1.3.3 Corporate law reform and the stakeholder question. Key question: for whose benefit does a company exist? 3 approaches. 1. Traditional shareholder-oriented model. Focuses solely on shareholders. Prevalent in the UK and Companies Act, 1973, SA. Excludes employees and other stakeholders. 2. Enlightened shareholder value, ESV, approach. Shareholders' interests remain primary. Directors may consider other stakeholders if it benefits shareholders. Balances short-term and long-term considerations. 3. Pluralist approach. Recognizes multiple stakeholders, employees, customers, creditors, communities. Directors balance all interests unless prioritization benefits the general body of stakeholders. Requires a legal shift in defining interests of the company. South African policy process. COSATU input, October 18, 2004, Nedlick. Advocated for stronger shareholder activism and board accountability. Called for recognition of broader stakeholders, labor, communities, consumers. Outcome. The Companies Act, 2008 adopted the ESV approach. Directors must promote company success primarily for shareholders, while considering stakeholder relationships. 1.3.4 The Enlightened Shareholder Approach in the Companies Act, 2008. Statutory effect. Expands rights for employees, trade unions, and minority shareholders. Key stakeholder protections include business rescue, special rights for employees, director accountability. Employees/trade unions can apply to declare a director delinquent, can restrain company actions inconsistent with the Act, can lodge complaints with regulatory bodies. Minority shareholder protections. Relief from oppressive/prejudicial conduct. Derivative action, lawsuit in company's name. Appraisal rights for dissenting shareholders. Director accountability. Common law duties, fiduciary and duty of care, now codified. Personal liability for company losses due to statutory non-compliance. Section 218(2). Broad liability clause. Any person contravening the Act is liable for losses caused. Extends beyond directors to any individual violating the Act. Underscore 1.4 Purpose and interpretation of the Companies Act, 2008. 1.4.1 Purpose, Section 7, aims. Promote economic development, entrepreneurship, and efficiency. Encourage transparency and high corporate governance standards. Balance rights of shareholders and directors. Facilitate company rescue and recovery while balancing stakeholder interests. Provide a predictable and effective regulatory environment. Legislative balance. Supports flexibility for businesses. Ensures accountability to stakeholders. 1.4.2 Interpretation, Sections 5 and 7, Constitutional Interpretation. Independent Institute of Education BKZN Law Society, courts must interpret laws to promote the Bill of Rights. Substance over form. Courts assess actual intent behind corporate actions. Section 6, courts can declare agreements void if they circumvent unalterable provisions. Case studies. 1. Sibakulu Construction v. Wedgwood Gulf Estate. Registered office equals company's principal office. One court has jurisdiction over business rescue matters. 2. Bassan v. On Point Engineers. Media requested access to securities registers. Court applied Bill of Rights principles, S39-2, and granted access. 1.5 Flexibility in the Memorandum of Incorporation, MOI, MOA as the founding document, replaces Memorandum and Articles of Association under 1973 Act. Key role of MOA. Differentiates company types, public, private, non-profit. Defines shareholder rights and director duties. Allows flexibility within a single Companies Act framework. This provides a structured and detailed summary while reducing redundancy. Let me know if you need any refinements. Next page. Structure of the Companies Act, 2008. The Companies Act, 2008 consists of 9 chapters and 5 schedules. Chapters of the Companies Act. 1. Interpretation, Purpose and Application. 2. Formation, Administration and Dissolution of Companies. 3. Enhanced Accountability and Transparency. 4. Public Offerings of Company Securities. 5. Fundamental Transactions, Takeovers and Offers. 6. Business Rescue and Compromise with Creditors. 7. Remedies and Enforcement. 8. Regulatory Agencies and Administration of the Act. 9. Offenses, Miscellaneous Matters, and General Provisions. Schedules of the Companies Act. 1. Provisions concerning nonprofit companies. 2. Conversion of close corporations to companies. 3. Amendment of laws. 4. Legislation to be enforced by the Commission. 5. Transitional arrangements. 1.6.1 Chapter 1, Interpretation, Purpose and Application, SS 1-10, Section 1, defines key terms in the Act. Sections 2-4, define key expressions. S2, related and interrelated persons, and control. S3, subsidiary relationships. S4, solvency and liquidity test. Section 5, General Interpretation Clause. Act must be interpreted in line with S7, Purpose of the Act. Section 6, courts can declare agreements void if they circumvent unalterable provisions. 1.6.2 Chapter 2, Formation, Administration and Dissolution of Companies, SS 11-83, Key Provisions. Incorporation of Companies, SS 11-21. Prohibition of reckless, negligent, or fraudulent trading, S22. Lifting of the corporate veil, S20. Financial statements and record keeping, SS 24-31. Capitalization, shares, and securities, SS 35-56. Corporate governance, shareholders' meetings, directors' duties, liabilities, SS 57-78. Winding up and deregistration of companies, SS 79-83. 1.6.3 Chapter 3, Enhanced Accountability and Transparency, SS 84-94. Public and state-owned companies must appoint a company secretary, appoint an auditor, establish an audit committee. 1.6.4 Chapter 4, Public Offerings of Company Securities, SS 95-111, regulates public share offerings, including prospectus requirements, SS 100-106, allotment of shares, SS 107-111. 1.6.5 Chapter 5, Fundamental Transactions, Takeovers and Offers, SS 112-127, regulates significant corporate changes, including disposal of major company assets, S 112, amalgamations, mergers, and takeovers. 1.6.6 Chapter 6, Business Rescue and Compromise with Creditors, SS 128-155, introduces business rescue procedures to prevent liquidation of financially distressed companies. Affected persons, directors, shareholders, creditors, employees, may initiate business rescue. Objective: prevent unemployment and financial loss by allowing restructuring. _ 1.6.7 Chapter 7, Remedies and Enforcement, SS 156-184, Alternative Dispute Resolution, ADR, SS 166-167, Investigations and Inspections, SS 176-179, Companies Tribunal, SS 180-184. Key Provisions. Compliance Notices by the Commission, S 171. Derivative Actions, S 165. Relief from Oppressive Conduct, S 164. _ 1.6.8 Chapter 8, Regulatory Agencies and Administration of the Act, SS 185-212, Regulatory Institutions. 1. Companies and Intellectual Property Commission, CIPC, SS 185-192, registers companies and intellectual property, ensures compliance with the Act. 2. Companies Tribunal, SS 193-195, adjudicates disputes between companies and the Commission, facilitates ADR mechanisms. 3. Takeover Regulation Panel, SS 196-202, regulates affected transactions. 4. Financial Reporting Standards Council, SS 203-204, recommends financial reporting standards. _ These chapters and schedules form the foundation of the Companies Act, 2008, regulating corporate structures, governance, accountability, public offerings, business rescue, and enforcement mechanisms. Next page. Structure of the Companies Act, 2008. The Companies Act, 2008 consists of 9 chapters and 5 schedules, structured as follows. Chapters of the Act. 1. Interpretation, Purpose, and Application. 2. Formation, Administration, and Dissolution of Companies. 3. Enhanced Accountability and Transparency. 4. Public Offerings of Company Securities. 5. Fundamental Transactions, Takeovers, and Offers. 6. Business Rescue and Compromise with Creditors. 7. Remedies and Enforcement. 8. Regulatory Agencies and Administration of the Act. 9. Offenses, Miscellaneous Matters, and General Provisions. Schedules of the Act. 1. Non-profit companies, provisions concerning non-profit entities. 2. Conversion of close corporations, rules for converting close corporations into companies. 3. Amendment of laws, amendments to existing legislation. 4. Legislation enforced by the Commission, laws under the jurisdiction of the Companies Commission. 5. Transitional arrangements, provisions for transitioning from previous corporate laws. Overview of key chapters. 1. Interpretation, Purpose, and Application, SS 1-10, defines key terms used in the Act, including S1, definitions, for example, ordinary and special resolutions. S2-4, related persons, control, subsidiary relationships, and solvency/liquidity test. S5, courts must interpret and apply the Act in line with its purposes. S7, S6, courts can declare arrangements void if designed to circumvent legislative prohibitions. 2. Formation, Administration, and Dissolution, SS 11-83, Company Incorporation, SS 11-21. Prohibition of reckless or fraudulent trading, S22. Lifting of the corporate veil, S20. Financial statements and record keeping, SS 24-31. Capitalization, shares, and securities, SS 35-56. Corporate governance, shareholder meetings, director duties, SS 57-78. Winding up and deregistration, SS 79-83. 3. Enhanced accountability and transparency, SS 84-94. Public and state-owned companies must appoint a company secretary, appoint an auditor, establish an audit committee. 4. Public offerings of securities, SS 95-111, regulates public share offerings, covers prospectus requirements, SS 100 to 106, and allotment of shares, SS 107 to 111. 5. Fundamental transactions, takeovers, and offers, SS 112 to 127, regulates major company transactions, including disposal of major assets, S 112, amalgamations, mergers, and takeovers. 6. Business rescue and compromise with creditors, SS 128 to 155, introduces business rescue proceedings for financially distressed companies. Application process and rights of affected persons. Ensures companies avoid liquidation where possible. Business rescue can be initiated by directors, shareholders, creditors, employees or trade unions. 7. Remedies and enforcement, SS 156 to 184, allows for alternative dispute resolution, ADR. SS 166 to 167, provides for investigations and inspections. SS 176 to 179, establishes the company's tribunal. SS 180 to 184, introduces enforcement mechanisms. Compliance notices, S 171, derivative actions, S 165, relief from oppressive conduct, S 164. 8. Regulatory agencies and administration, SS 185 to 212, establishes 4 regulatory bodies. 1. Companies and Intellectual Property Commission, SS 185 to 192, registers companies and enforces compliance. 2. Companies Tribunal, SS 193 to 195, handles disputes between companies and the Commission. 3. Takeover Regulation Panel, SS 196 to 202, regulates affected transactions. 4. Financial Reporting Standards Council, SS 203 to 204, recommends financial reporting standards. This summary provides a structured overview of the Companies Act, 2008, covering its key chapters and provisions. Let me know if you need further details. Next. 1.6.9 Chapter 9, Offenses, Miscellaneous Matters and General Provisions, SS 213 to 225. Chapter 9 deals with a number of issues such as offenses, for example, false statements or reckless trading, penalties, the power to make regulations, and transitional arrangements. Page 1.6.9 Chapter 9, Offenses, Miscellaneous Matters, and General Provisions, SS 213 to 225, covers offenses, penalties, and general provisions related to corporate conduct. Key provisions. Offenses, false statements, reckless trading, penalties, consequences for violations, regulatory power, authority to issue regulations, transitional arrangements, provisions for implementing the Act. This chapter finalizes the Companies Act, 2008, ensuring enforcement and regulatory compliance. Let me know if you need further details. Next. Page 1.7 Key Concepts and Features of the Companies Act, 2008. Company formation. Any person has the right to form a company. Minimal requirements for incorporation. Memorandum of Incorporation, MOI. The sole governing document of a company contains unalterable provisions, mandatory under the Act, and alterable provisions, can be modified for stakeholders' needs. Must align with the Companies Act unless explicitly allowed to deviate. Regulatory system and reporting. Simplified regulation, with stricter requirements for state-owned, public, and certain private companies. Some companies are exempt from audits or independent financial reviews. Differential reporting. Public companies must follow International Financial Reporting Standards, IFRS, whereas private companies have lenient requirements. Solvency and liquidity focus. Replaces the traditional capital maintenance concept. Directors must apply the solvency and liquidity test before issuing dividends or repurchasing shares. Enlightened shareholder value approach. Protects shareholders while extending rights to other stakeholders, employees, trade unions. Legal standing granted to interested parties beyond shareholders to seek relief. Business rescue provisions. Aims to rehabilitate financially distressed companies instead of liquidation. Employees and trade unions can initiate rescue proceedings. Balance between regulation and business autonomy. Directors have discretion in running the company within the legislative framework. Limits judicial and regulatory interference in corporate decision-making. Director duties and accountability. Partial codification of directors' fiduciary duties and duty of care. Courts can declare a delinquent director or place them on probation for misconduct. Sanctions and compliance. Emphasis on administrative remedies over criminal penalties. Directors personally liable for company losses in certain situations. Compliance enforcement through regulatory bodies. Companies and Intellectual Property Commission, CIPC, Takeover Regulation Panel, TRP. Compliance options include dispute resolution, compliance notices, or court action. Prohibition of misconduct. Bans reckless, grossly negligent, and fraudulent trading. Allows lifting the corporate veil in cases of serious abuse of corporate personality. Transitional arrangements. Companies under previous laws are deemed to comply with the Companies Act, 2008. The Companies Act, 1973 is largely replaced, except in insolvency matters until a uniform law is introduced. 1.8 Types of companies. Primary distinction. Profit companies. Non-profit companies. Types of profit companies. 1. Public company. 2. State-owned company. 3. Personal liability company. 4. Private company. Each type is detailed in Chapter 2. Let me know if you need further breakdowns. Next page. Study notes, the Companies Act, 2008 and the Common Law. 1.9 The Companies Act, 2008 and the Common Law. The Companies Act, 2008 is not a complete codification of South African company law. The Act functions as a superstructure built on the foundation of common law. Common law remains applicable unless explicitly abolished or modified by statute. The common law helps interpret the Act and applies when the Act is silent. 1.9.1 When the Act is silent, the common law applies. Example, security for costs, S13 of the Companies Act, 1973. The Companies Act, 2008 does not have an equivalent of S13 from the Companies Act, 1973. Wendigold, Proprietary, Limited v. Precious Prospect Trading 80, Proprietary, Limited. The absence of S13 signifies a policy shift, ensuring access to courts per S34 of the Constitution. The common law applies to security for costs in the absence of a statutory provision. Boost Sports Africa, Proprietary, Limited v. South African Breweries, Proprietary, Limited. Courts derive power from S173 of the Constitution to regulate their own process and develop common law. Even without a statutory provision, the court has discretion on security for costs. Plaintiffs must provide evidence of inability to furnish security. Mountain Service Provider case, courts must prevent plaintiffs from hiding behind the corporate veil to evade liability. 1.9.2 Common law continues unless abolished or modified by the Act. South African common law originates from Roman Dutch law and English law. Courts may refer to historical legal texts when adapting the law to new situations. The Companies Act, 2008 is detailed but does not replace all common law rules. 1.9.3 The Act supplements and expands common law principles. Example, Directors' Duties, S76(3) of the Companies Act, 2008. The Act sets out fiduciary duties and duty of care and skill. Common law is essential for interpreting the Act, as statutory provisions build upon existing legal principles. Architects C.C. Mphalwa and Phillips v. Fieldstone Africa, Proprietary, Limited. Fiduciary duty prevents conflicts of interest and prohibits directors from making secret profits. Directors must act in the best interests of the company and disclose conflicts. 1.9.4 The Act abolishes some common law principles. Example, Declaration of Delinquency, S162 of the Companies Act, 2008, Giwala v. Guernsey Property Limited. S162(5)(c) allows courts to declare directors delinquent, with a minimum 7-year ban. The constitutionality of S162(5)(c) was challenged but upheld. The court ruled that protecting public and shareholder interests justifies restricting directors' rights. Conclusion. The Companies Act, 2008 interacts with common law in 4 ways. 1. Common law applies when the Act is silent. 2. Common law remains unless expressly abolished or modified. 3. The Act supplements and expands common law principles. 4. Some common law principles are abolished by the Act. Courts rely on common law for interpretation and to fill gaps in the legislation. Next page. Study notes on the relationship between common law and the Companies Act, 2008. 1.9.2 Common law principles continue unless expressly abolished. Courts have held that common law principles continue to apply unless the Companies Act, 2008 explicitly or implicitly abolishes them. The Act does not automatically replace common law principles unless expressly stated. Case study, Liamisa Investment Holdings, RF, Limited and another v. Kirkinis and others. Shareholders sought to recover losses from directors due to a decline in share value. Alleged breach of S22(1), prohibiting reckless trading. S76(3), directors' duties. S218(2), liability for contravening the Act. Court rejected the claim, stating, the legislature did not intend to discard common law requirements, fault, foreseeability, causation, proper plaintiff. If intended, the Act would have included explicit wording like notwithstanding anything in the common law. Applied common law principle of causation and dismissed the claim. 1.9.3 Companies Act supplements and expands common law. Some provisions of the Companies Act supplement and expand upon common law principles. Example, lifting the corporate veil, S29. Courts may disregard a company's juristic personality if its incorporation or activities constitute an unconscionable abuse. Ex parte Gore and others NNO, Court ruled that S29 expands the common law position, making it easier to lift the corporate veil. 1.9.4 Companies Act abolishes certain common law principles. S165, Derivative Actions. Abolishes common law rights of individuals to institute legal proceedings on behalf of a company, replaced by statutory provisions under S165. Moritzen v. Greystones Enterprises, Proprietary, Limited and another, Court confirmed that S165 introduced a completely new regime for derivative actions. Summary of the chapter. 1. Companies Act, 2008 came into effect on May 1, 2011, replacing the Companies Act, 1973, except for insolvency provisions. 2. Purpose, encourages business activity with flexibility while ensuring corporate accountability. 3. Key reforms. Business rescue replaces judicial management. Solvency and liquidity test replaces capital maintenance. 4. Close Corporations Act. Existing close corporations continue. No new close corporations allowed after May 1, 2011. 5. Legislative process. Policy paper, 2004, NEDLIC agreements, trade union pressure. 6. Corporate law reform objectives, NEDLIC. Simplification, flexibility, corporate efficiency, transparency, predictability. 7. Shareholder approach. Enlighten shareholder value. Directors must balance shareholder interests with stakeholder relationships. 8. Flexibility. Companies can regulate themselves via their Memorandum of Incorporation, MOI. 9. Regulation. Partial codification of directors' duties. 10. Sanctions. Decriminalization of offenses where possible. 11. Prohibitions. Reckless trading, gross negligence, fraudulent conduct. Next page. Chapter 2. 2.1 Companies and other business entities. Why incorporate a business? A person does not need to form a company to trade or open a business. Some may benefit from trading in their own name. There is a misconception that forming a close corporation or a company is mandatory for business ventures. This is incorrect. Various factors should be considered when choosing a business entity. Number of persons involved in the business. Extent of involvement of each person. Capital requirements and sources, equity or debt, customer and client requirements. Strategic objectives of the business. Business structures include companies, close corporations, business trusts, partnerships, combination structures, for example, a company using assets held in a trust. Tax implications must be considered, as the South African tax system is not entity neutral. Companies Act, 2008 provides flexibility in structuring companies through the Memorandum of Incorporation, MOI. Income Tax Act recognizes different company types and grants favorable tax treatment to some, for example, small business corporations, micro-businesses. Companies in context. Sole proprietorship. Simplest way to do business. Few formalities, only trading licenses required. Personal assets are at risk if sued. Partnership. No separate legal personality. Joint and several liability. Each partner may be personally liable for all business debts. No perpetual succession. The partnership dissolves if a partner dies, retires, or becomes insolvent. Discussed in Chapter 17. Business trusts can conduct business activities, but often misunderstood and highly regulated. Discussed in Chapter 18. Close corporation. Benefits of perpetual succession, continues even if members change. On legal existence, can enter into contracts and own assets. Clients and suppliers deal with the corporation itself, not the members. Allows for stability and accumulation of goodwill. Discussed in Chapter 16. Companies. Perpetual succession, like close corporations, enable both active and passive investors to contribute capital in exchange for shares. Shares allow investors to easily transfer ownership, offer shareholder protection if the business fails or faces legal action. Next page. Business entities compared. Table 2.1, Similarities and differences between business entities. Issue company, close corporation, partnership, business trust. Applicable law: Companies Act, 2008, Common Law, Case Law. Close Corporations Act, Common Law applies. Based on contract law and common law. Trust Property Control Act, Trust Law from Case Law. Different types: public, private, personal liability, non-profit, state-owned, and external companies. One type, but member rights can be defined in an association agreement. Various types, including anonymous partnerships, vesting trusts, discretionary trusts, and business trusts. Separate entity: a juristic person separate from shareholders. A juristic person separate from members. Not a separate legal person, assets jointly owned. Not a legal person, assets owned by trustees. Control of business: directors manage and control. Members control. Determined by partnership agreement. Trustees control. Perpetual succession exists independently until wound up or deregistered. Exists independently of members. No perpetual succession, dissolves if partner exits. Can provide for perpetual succession. Number of participants: no limit on shareholders, except in private companies. Max 10 members. No limit on partners. No limit on trustees or beneficiaries. Personal liability: shareholders not personally liable unless they provide guarantees. Members have fiduciary duty and may be liable. Partners are jointly and severally liable. Beneficiaries not liable, trustees liable for misconduct. Rights of parties: MWA determines shareholder rights. Association agreement determines member rights. Partnership agreement determines rights. Trustee determines trustee and beneficiary rights. Duties towards business: directors have statutory and fiduciary duties, shareholders owe no duties. Members owe fiduciary duties. Partners have fiduciary duties to each other. Beneficiaries have no fiduciary duty. Trustees have statutory duties. Financial records required by Companies Act, JSE: listed companies must follow King IV Code. Required by Close Corporations Act. Partnership agreement determines record keeping. Trustees must maintain financial records and open a trust bank account. Auditor or accounting officer: public companies must have auditors, some private companies need either an auditor or accounting officer. Must have an accounting officer, no audit required. No requirement unless specified in partnership agreement. No audit required by law, but trustee may require one. Business name regulations: strictly regulated. Strictly regulated. Not strictly regulated. Not regulated, names cannot be reserved. This table highlights the key legal, financial, and operational differences between the major business structures in South Africa. Next page. Study notes: Business entities and legal personality of companies. 2.1 Business entities compared. Comparison of business entities, Table 2.1 Issue company, close corporation, CC, partnership, business trust. Applicable law: Companies Act, 2008 plus Common Law, Case Law, Close Corporations Act plus Common Law, Law of Contract plus Common Law, Trust Property Control Act plus Case Law. Types: public, private, personal liability, non-profit, state-owned, external. Only one type, but rights determined by association agreement. Different types, for example, anonymous partnerships, vesting trusts, discretionary trusts, business trusts. Separate legal entity: yes. Separate from shareholders and directors: yes. Separate from members: no. Assets jointly owned by partners: no. Trust is a contract, assets owned by trustees. Control of business: directors manage the company, members control the CC. Partnership agreement determines control, trustees manage the trust. Perpetual succession: yes, yes, no. Dissolved on change of partners, yes, unless trustee provides otherwise. Number of participants no limit, maximum 10 members, no limit on trustees/beneficiaries. Personal liability, shareholders not liable unless standing surety members may be personally liable under certain circumstances, partners jointly and severally liable for debts, trustees can be liable for misconduct/negligence. Rights of parties determined by MWA, determined by association agreement, determined by partnership agreement, determined by trust deed. Duties towards business, shareholders have no duties. Directors owe fiduciary duties, members owe fiduciary duties, partners owe fiduciary duties, trustees owe fiduciary duties, not beneficiaries. Financial records required under Companies Act, JSE rules required under Close Corporations Act. As per partnership agreement, trustees must account for trust assets. Auditor/accounting officer, public companies must have an auditor, private companies may require one, requires an accounting officer. No audit required, no auditor unless required by agreement, no requirement, but trust deed may require one. Business name regulation, strictly regulated, not strictly regulated, no name regulation. _ 2.2 Legal personality and key features of a company's juristic personality. A company is a separate legal entity from its shareholders, leading to the following implications. Directors manage the company, shareholders do not. Limited liability. Shareholders are not responsible for company debts. Company assets belong to the company, not shareholders. Legal actions must be brought by the company, not shareholders. Case study: limitation of shareholder powers. Letsing Diamonds Limited v JCI Limited, Trinity Asset Management, Proprietary, Limited v Investec Bank Limited. Shareholders challenged agreements entered by the company. Court ruled shareholders are strangers to the company's contracts. If shareholders lose confidence in directors, they can vote them out, but cannot interfere in company contracts. 2.2.1 Legal personality, limitation of shareholder liability. Incorporation generally results in limited liability for shareholders. Exception: personal liability companies, directors are personally liable for company debts. 2.2.2 Legal personality, shareholders do not own company assets. Airport Cold Storage, Proprietary, Limited v Ibrahim. A company's assets belong to the company, not shareholders. Dadu Limited v Krugersdorp Municipal Council. Property is vested in the company, not its shareholders. Salomon v Salomon & Co Limited. Once incorporated, a company is separate from its promoters, regardless of intent. 2.2.3 Legal personality, a wrong to a company is not a wrong to a shareholder. Itsikowitz v Absa Bank Limited. A shareholder sued a bank for company liquidation. Court held a wrong to a company is not a wrong to a shareholder. London and Others v Department of Transport. Shareholders sued for company liquidation due to contract refusal. Court ruled duty was owed to the company, not shareholders. 2.2.4 Legal personality, incorporation and registration. Companies Act, 2008, S. 19.1, incorporation separate from registration. S. 14.4, registration certificate equals conclusive evidence of incorporation. Potential liability gap exists before registration is completed. No equivalent to S. 172 of Companies Act, 1973, which prohibited business activity before registration. _ These notes summarize the key principles regarding business entities and corporate legal personality, including relevant case law and statutory provisions. Let me know if you need further clarifications or modifications. Next page. Study notes, branches and divisions of a company. 2.3 Branches and divisions of a company. A branch or division of a company is not a separate legal entity. It remains an integral part of the company, even if it operates under a different name. Case studies, divisions of a company. Absa Bank Limited v Blicknote. In 4 similar cases, a company may create separate operating divisions for practical reasons. A division conducting business under a different name, for example, United Bank as part of Absa, does not create a separate legal entity. Legally, the entity remains one company despite external perceptions of separation. Tuning Fork, Proprietary, Limited v Kilburn Auto Enterprises, Proprietary, Limited. A division remains part of the company, even if it has a distinct name, operates separate accounts, employs different personnel. Profits/losses from all divisions contribute to the company's overall financial position. Legal principle. A company cannot be split into multiple separate juristic personalities. A company may trade under multiple names, but these do not have independent legal existence. Let me know if you need any refinements. Next page. Study notes, Incorporation and Limited Liability. 2.4 Incorporation and Limited Liability, Financial Risk of Company Controllers. Incorporation limits liability for shareholders and directors. However, abuse of corporate personality can result in personal liability. 2.4.1 Lifting the corporate veil, Common Law in Section 29, courts look at substance over form. Corporate personality cannot be used to justify wrongdoing. 2.4.1.1 Common Law, Piercing the corporate veil. The corporate veil separates a company's assets/liabilities from its controllers. Courts may disregard this separation in cases of fraud, dishonesty, improper conduct, using a company as a sham or facade. Piercing the veil was historically seen as a drastic remedy, used only when justice required it. Case studies, Common Law Lifting of the Corporate Veil. Airport Cold Storage, Proprietary, Limited v. Ibrahim. A close corporation was liquidated while owing R278,377 to a creditor. The corporation had no assets, so the creditor sued the member and his father personally. The court ruled, veil piercing is only allowed in special circumstances, for example, where a company is a mere facade. The defendants ignored corporate formalities and used the business for personal interests. They were jointly and severally liable for the corporation's debts. Didros, Proprietary, Limited v. Telephone Beverages CC. Fraud, dishonesty, or improper conduct can justify disregarding corporate personality. A company used to evade a restraint of trade may have its veil pierced. Liberco Fashions CC v. Lee. Mrs. Lee signed a restraint of trade agreement personally. She then used a company to engage in the prohibited trade. The court pierced the corporate veil to hold her personally liable. Underscore. 2.4.1.2 Section 29 of the Companies Act, 2008. Expands the common law by making veil piercing easier. Section 29. If the incorporation, use, or acts of a company constitute an unconscionable abuse of juristic personality, the court may 1. Deem the company not to be a juristic person for specific rights, obligations, or liabilities. 2. Issue any further appropriate order to address the abuse. Companies Act, 2008. Decriminalized, non-compliance is no longer a crime. However, directors can still be held personally liable for losses caused by wrongdoing. Case study, Section 29 Lifting the corporate veil. Ex parte Gore and others NNO, a group of companies misused investors' funds, moving them between entities. Investors suffered losses due to this disregard for corporate personality. Court held, investors could sue the holding company directly instead of individual entities. Section 29 broadens veil-piercing grounds beyond common law. Unconscionable abuse includes sham, fraud, and misusing corporate personality. No requirement for this remedy to be used only as a last resort. Who can apply? Section 29 allows any interested person to seek veil-piercing. Court ruled liquidators had a direct interest and qualified as interested persons. Next page. 2.4 Incorporation and Limited Liability, Financial Risk to those behind a company. 2.4.1 Lifting the corporate veil, Common Law in Section 29, incorporation provides limited liability but cannot be misused to justify wrongdoing. Courts focus on substance over form and will not allow legal entities to be used to protect fraud or crime. 2.4.1.1 Common Law. Cape Pacific Limited v. Lubner Controlling Investments, Proprietary, Limited. Courts can disregard separate personality if a company is misused for fraud or improper purposes. Airport Cold Storage, Proprietary, Limited v. Ibrahim. Directors and members usually have protection from personal liability, but this is not absolute. Courts can pierce the corporate veil in exceptional circumstances where a company is used as a mere facade or for fraudulent, dishonest, or improper conduct. Piercing the veil is a last resort to ensure justice. Case studies, Common Law Veil Piercing. Airport Cold Storage, Proprietary, Limited v. Ibrahim. A close corporation was liquidated, leaving a creditor unpaid. The court found that the defendants ignored the corporate identity when it suited them and could not then hide behind it. Held, defendants were personally liable for the company's debts. Didros, Proprietary, Limited v. Telephone Beverages CC. Courts balance preserving corporate personality with policy considerations favoring veil piercing in cases of fraud or improper conduct. Libergo Fashions CCB Lee. Mrs. Lee personally signed a restraint of trade, then used a company to circumvent it. The court held that the company's competition with the plaintiff amounted to wrongful assistance in breaching the agreement. 2.4.1.2 Section 29 of the 2008 Companies Act expands common law principles on lifting the corporate veil. A court may disregard a company's juristic personality if its incorporation, use, or acts constitute an unconscionable abuse of corporate identity. Allows courts to declare that a company is not a juristic person in respect of certain rights, obligations, or liabilities. Courts can make any further order necessary to give effect to such a declaration. Personal liability applies for wrongdoing, even in a decriminalized Companies Act. Case study, Section 29 Veil piercing. Ex parte Gore and others NNO. A group of companies failed to treat their entities as separate legal persons, moving investor funds between entities improperly. Investors suffered losses, and the court applied S29 to disregard the corporate separateness of the entities. Key findings. S29 expands veil piercing beyond common law by covering sham structures, fraud, and unconscionable abuse. The remedy is not drastic but a necessary tool to prevent illegitimate corporate use. Courts can disregard corporate personality without requiring the absence of alternative remedies. Any interested person may apply for veil piercing, including liquidators. 2.4.2 Section 218(2) of the Companies Act, 2008. Holds any person personally liable for loss or damage suffered due to contravention of the Act. Severe financial risk to directors, as it allows monetary claims against them for violations. Not limited to directors, applies to anyone violating the Act, for example, reckless trading under S22. Case study, Section 218(2) Liability. Liamis Investment Holdings, RF, Limited v. Kirkinis and others. Shareholders sued directors for a drop in share value, arguing that directors breached S22(1), reckless trading, and S76(3), fiduciary duty. Court's ruling. S218(2) does not alter common law to allow shareholders to claim reflective losses. No causal link between a company's loss and shareholders' loss and share price decline. The legislature did not intend to discard legal principles like fault, causation, and the proper plaintiff rule. Outcome: shareholders' claim failed. Next page. 2.5 Types of company. The Companies Act, 2008 recognizes two main types of companies. 1. Profit companies, incorporated for financial gain for shareholders. May have one or more shareholders with no maximum limit. Previously, private companies were limited to 50 shareholders under the 1973 Act. 4 types of profit companies. Public companies. State-owned enterprises. Personal liability companies. Private companies. 2. Non-profit companies, incorporated for a public benefit or an object other than financial gain. 2.5.1 Public company. Any profit company that is not a state-owned enterprise, private company, or personal liability company. Shares may be offered to the public and are freely transferable. May be listed or unlisted on a stock exchange. The Memorandum of Incorporation, MOI, determines whether a company has public status. 2.5.2 State-owned company, SOC, a profit company that is either listed as a public entity in Schedule 2 or 3 of the Public Finance Management Act, or owned by a municipality, a national government business enterprise under state control. Conducts business on ordinary commercial principles but not fully funded by tax revenue. Examples of SOCs: South African Airways, Eskom, Telkom, SABC, Post Office, PRASA, Petro SA, CSR, Public Investment Corporation, PIC, Brandwater, SA Bureau of Standards. PIC is the largest investor on the JSE, managing funds for public sector entities, for example, Government Employees Pension Fund. 2.5.3 Personal liability company. Used mainly by professionals, for example, attorneys, stockbrokers, entrepreneurs. Enjoys corporate benefits, for example, perpetual succession. Directors are jointly and severally liable for all contractual debts and liabilities incurred during their tenure. The MOA must expressly state that it is a personal liability company. Case study: Sonnenberg McLaughlin Incorporated v. Spiro. A personal liability company sought to hold a former director liable for debts incurred during his tenure. Court ruling. The purpose of a personal liability company is to impose joint and several liability on directors for company debts. However, the company cannot claim reimbursement from former directors after settling debts itself. MWA amendments for personal liability companies. If a MWA amendment changes a personal liability company into another type, it must give at least 10 business days notice to regulatory authorities overseeing the business. Persons who relied on directors' joint liability in their dealings with the company. Case study, Medex, Rontberg, Proprietary, Limited v. Branfield. Directors of personal liability companies are personally liable, but if a third party agrees not to sue a director, that agreement is enforceable. Facts. A landlord sought to hold a medical practitioner personally liable for rent owed by his company. The practitioner claimed an oral agreement exempted him from liability. Court ruling. If such an agreement existed, the director would not be liable. However, the practitioner failed to prove the agreement. Held, the practitioner was personally liable for the company's debt. Case study, Olivina Gota SSH, Haudang, Incorporated. To hold a director personally liable, a plaintiff must prove 1. The plaintiff is a creditor of the company. 2. The relationship is contractual. Facts. A purchaser paid funds to a law firm, an incorporated company, for a property transaction. A partner stole the money. The purchaser sued the other directors personally. Court ruling. Since the law firm had a contractual obligation to hold the funds in trust, the plaintiff was a creditor. Held. The directors were personally liable for the stolen funds. Next page. Study notes, private and nonprofit companies. 2.5.4 The private company. A private company is a profit company whose MWA prohibits offering shares to the public, restricts the transferability of shares. No restriction on the number of shareholders. Companies Act, 2008. Previously, Companies Act, 1973, limited to 50 shareholders. Key case, Smuts v. Buyens, Markles, Edms, VPK v. Buyens. Court held that restricted transferability is an essential characteristic. The MWA must expressly restrict transferability of securities. Possible restrictions include preemptive rights. Existing shareholders get first right to buy shares before external parties. Board approval. Directors must approve share transfers. Section 15(7). Shareholders' agreements must be consistent with the Act and MWA. Case study, Visser Citrus, Proprietary, Limited v. Goedhoop Citrus, Proprietary, Limited and others. Concerned board refusal to approve a share transfer. MWA clause, board had absolute discretion to decline a transfer without giving reasons. Court held. Restriction on transferability is a common feature of private companies. Companies Act, S82b, 2, requires such restrictions. MWA can grant board discretion without requiring reasons. Directors must act bona fide in the best interests of the company. Case study, Sindler Noviges and 6 other cases. One shareholder offered entire 50% stake to a third party. Other shareholder only wanted to buy 3 shares, not all. Court held. Preemptive rights must be strictly interpreted. Offer for all shares means the entire shareholding must be taken. A common restriction is a clause giving directors discretionary power to reject transfers. Underscore. 2.5.5 The nonprofit company. Previously recognized under S21 of the Companies Act, 1973. Regulated under Schedule 1 of the Companies Act, 2008. Main characteristics. Must have a public benefit, cultural, social, or community purpose. All assets and income must advance the company's objectives. Can own securities in a profit company or engage in activities ancillary to its objectives. Restrictions on financial benefits. Directors/members cannot receive financial gain, except reasonable remuneration for services. Upon dissolution, net assets must go to another nonprofit entity with similar objectives. Members. Not required, but MWA may allow members. 2 types. Voting and non-voting members. Voting members must have at least 1 vote. Terminology. Non-profit companies members. Profit companies shareholders. Incorporators are the first directors and first members, if MWA allows members. Next page. Study notes, transitional provisions, close corporations, and external companies. 2.6 Transitional provisions and close corporations. Schedule 5 of the Companies Act, 2008, ensures a smooth transition from the Companies Act, 1973, facilitates company formation and maintenance, especially for small businesses. Close Corporations Act remains in force indefinitely for existing close corporations. No new close corporations can be incorporated after the commencement of the Companies Act, 2008. Existing close corporations can choose to convert to companies under the Act. Companies Act, 2008 prohibits conversion of companies, formed under Companies Act, 1973, into close corporations. Formation of new close corporations. Future of close corporations, explanatory memorandum to the Companies Bill, 2008. The DTI believes the new Companies Act sufficiently simplifies company formation. Retaining the Close Corporations Act for new entities is unnecessary. Existing close corporations can continue indefinitely until their members choose to convert. _ 2.7 External companies. An external company is a foreign company conducting business or non-profit activities in South Africa. Section 23(2). A foreign company is deemed to be conducting business in South Africa if it has one or more employment contracts in SA, engages in a pattern of activities for at least 6 months, suggesting continuous business intent. A foreign company is not conducting business solely by holding shareholder/board meetings in SA, maintaining bank accounts in SA, establishing offices/agencies for securities registration, creating/acquiring debts, mortgages, or security interests in SA, securing/collecting debts or enforcing security interests, acquiring property interests in SA. Registration requirements. Section 23(1). Must register with the Companies Commission within 20 business days after starting business in SA. Must maintain at least one office in South Africa. Required registration details. Name and address of a person accepting service of legal documents. Other prescribed company information. Commission issues a registration certificate upon compliance. Key case, Sibakulu Construction, Proprietary, Limited v Wedgwood Village Golf and Country Estate, Proprietary, Limited. Court confirmed that the registered office must be the company's own maintained office, S23 of Companies Act, 2008. Previously, Companies Act, 1973, companies could use an address for convenience, for example, their auditor's office. Companies Act, 2008, S23(3), now requires the registered office and principal place of business to be the same address. Key case, Dairy Board v John T. Rennie & Co., Proprietary, Limited. A company could have both a registered office and a principal place of business for jurisdictional purposes. Sibakulu Construction case distinguished this by confirming Companies Act, 2008 requires one address. Regulation of external companies. Balances encouraging foreign investment with ensuring compliance. Limited compliance obligations for external companies. Not required to prepare annual financial statements. No audit requirement, even if financial statements are voluntarily prepared. Non-compliance. If an external company fails to register within 6 months, the Commission may issue a compliance notice to register. Order the company to cease business activities in SA if registration is not completed. Next page. 2.6 Transitional Provisions and Close Corporations. Schedule 5 of the Companies Act, 2008 ensures a smooth transition from the Companies Act, 1973. The Act simplifies company incorporation and supports small businesses. Close Corporations Act continues indefinitely, but no new close corporations may be incorporated. Companies under the Companies Act, 1973 cannot convert to close corporations. Existing close corporations may continue until members decide to convert to companies. Future of close corporations. Explanatory memorandum to the Companies Bill, 2008 states. New Companies Act is streamlined to accommodate small businesses. Existing close corporations may retain their status but cannot be newly formed. The Close Corporations Act remains valid only for existing entities. _ 2.7 External companies. Definition: a foreign company conducting business or non-profit activities in South Africa, S23(2). A foreign company is deemed to conduct business if it has employment contracts in South Africa, engages in activities for at least 6 months, suggesting ongoing business. A foreign company is not considered to be conducting business solely by holding shareholder or board meetings in South Africa, maintaining bank accounts or securities transfer offices, acquiring or securing debts, mortgages, or interests in local property. Registration requirements. Must register with the Commission within 20 business days of starting activities in South Africa. Must maintain at least one office in South Africa. Must provide the name and address of a representative for service of documents. The Commission issues a registration certificate after submission. Case study: Registered Office of a Company. Sibakula Construction, Proprietary, Limited v Wedgwood Village Golf and Country Estate, Proprietary, Limited. The court held that under S23(3) of the Companies Act, 2008, a registered office must be an office maintained by the company itself, not a third party's address. The Companies Act, 1973 allowed the registered office to be separate from the principal place of business, but S23(3) now requires both to be the same. Dairy Board v John T. Rennie & Co., Proprietary, Limited. Confirmed that a company could reside at both the registered office and the principal place of business for jurisdictional purposes. Regulation of external companies. Encourages foreign investment while ensuring accountability. Most provisions of the Act do not apply to external companies. External companies are not required to prepare audited financial statements. Noncompliance. If an external company fails to register within 6 months, the Commission may issue a compliance notice requiring registration or cessation of business. 2.8 Domesticated companies. Definition: a foreign company transferring its registration to South Africa under S13(5)(9). Upon transfer, the company is treated as originally incorporated under the Companies Act, 2008. Must comply with South African laws. Requirements for transfer. The foreign jurisdiction must permit such a transfer. Shareholders must approve the transfer. The majority of assets, shareholders, and directors must be South African. Must pass the solvency and liquidity test after registration. The company must no longer be registered in another jurisdiction. Restrictions on transfer, S13(7). A foreign company cannot transfer its registration if it issues bearer shares or has outstanding bearer shares, is in liquidation or subject to receivership, is undergoing business rescue or insolvency proceedings, has unresolved court applications for liquidation or insolvency. 2.9 Incorporation of a company. Key objectives of company law reform. Flexibility and simplicity in corporate structures. The Companies Act, 2008 allows for various types of businesses. Incorporation is a right. The explanatory memorandum to the Companies Bill, 2008 states, incorporation is a right, not a privilege. Minimal regulatory requirements for formation. Maximum flexibility in company design and structure. 2.9.1 Notice of Incorporation and Memorandum of Incorporation, MOI, Notice of Incorporation, S13(1). Filed with the Commission to register a company. Must be accompanied by the prescribed fee and MOI. Memorandum of Incorporation, MOI, S1, S15. Determines the rights, duties, and responsibilities of shareholders, directors, and other stakeholders. Defines the type of company, public, private, etc. Can be simple or complex, allowing for minority shareholder protections and restrictions on directors' powers. 2.9.2 Flexibility within the MOI. The MOI must be consistent with the Companies Act, 2008. 3 types of provisions in the MOI. Unalterable provisions, cannot be removed but may be made stricter. Alterable provisions, may be modified to suit the company's needs. Default provisions, apply if the MOI does not specify otherwise. Case study: MOI must be consistent with the Act. Benthivime v Benthivime. A clause in the company's articles attempted to give preference shareholders the right to approve major asset disposals. This was inconsistent with S228 of the Companies Act, 1973, which required shareholder approval in a general meeting. The court held that an MOI cannot override the Act. Key provisions in an MOI. Company's objects and powers. Types and limitations of shares. Restrictions on directors' and shareholders' powers. Shareholders' rights and voting powers. Audit requirements. Amendment procedures for the MOI. Flexibility of the MOI. Explanatory memorandum, Companies Bill, 2008. MOI must protect shareholders' interests. Default rules exist but can be altered to suit company needs. A company cannot contract out of the Act, reinforcing S61's anti-avoidance provisions. Case study: Right of shareholder to appoint a proxy. Section 58(1). A shareholder has the right to appoint a proxy at any time. Berry v Clearwater Estates NPC. MOI required proxies to be lodged 48 hours before a meeting. Court ruled that S58(1) is unalterable, and the MWA provision was void under S. 15.1. However, S. 58.3c is alterable, allowing modifications to proxy-related processes. Underscore. Summary of key points. Close Corporations Act continues indefinitely, but no new registrations are allowed. External companies must register within 20 business days but are exempt from certain financial regulations. Domesticated companies must transfer registration lawfully and meet South African residency and asset requirements. Company incorporation is a right, and the MWA provides flexibility but must comply with the Act. The MWA must align with the Act, and unalterable provisions cannot be removed but may be made stricter. Case law confirms that MWA provisions inconsistent with the Act are void. Next. Page 2.8. Domesticated companies. A domesticated company is a foreign company that transfers its registration to South Africa under S. 13.5.9 of the Companies Act, 2008. Once transferred, it is considered as if originally incorporated under the South African Companies Act. Requirements for transfer. S. 13. The foreign jurisdiction's law must permit such a transfer, and the company must comply with its legal requirements. Shareholders must approve the transfer. Most assets and business must be located in South Africa, excluding subsidiaries incorporated outside the Republic. Majority of shareholders must reside in South Africa. Majority of directors must be South African citizens. After transfer, the company must meet the solvency and liquidity test. It must no longer be registered in another jurisdiction. Restrictions on transfer. S. 13.7. Even if the above conditions are met, a foreign company cannot transfer its registration if it is allowed to issue bearer shares or has outstanding bearer shares. It is in liquidation. A receiver or manager has been appointed over its assets. It is undergoing business rescue proceedings or has an approved business rescue plan in place. A court application is pending to wind up, liquidate, or declare it insolvent. Underscore. 2.9. Incorporation of a company. The South African corporate law reform aimed at 5 key objectives agreed upon at NEDLAC, focusing on flexibility and simplicity. The Companies Act, 2008 provides for a range of corporate structures, from simple to complex businesses. Incorporation as a right. The explanatory memorandum to the Companies Bill, 2008 states that incorporation is a right, not a privilege. The law minimizes incorporation requirements, allows flexibility in company design, reduces regulatory oversight on company formation. Underscore. 2.9.1 The Notice of Incorporation and the Memorandum of Incorporation, MOI. A company is incorporated by filing a Notice of Incorporation, S. 13.1, with the Companies and Intellectual Property Commission, CIPC. The MOI must accompany the notice and sets out the rights, duties, and responsibilities of shareholders, directors, and stakeholders. Purpose of MOI. Determines company structure, for example, public or private. Defines stakeholder rights and obligations. Provides flexibility, accommodating simple or complex governance structures. Role of the Commission, S. 186, maintains accurate company records. Ensures transparency for stakeholders. Underscore. 2.9.2 Flexibility within the MOI. The MOI must comply with the Act, and any inconsistent provision is void. 3 types of provisions. Unalterable, cannot be changed, for example, shareholder rights under S. 58.1. Alterable, can be modified to suit specific company needs. Default, apply unless expressly changed in the MOI. Higher standards in MOI, S. 15.2a, 3, while unalterable provisions cannot be abolished, the MOI can impose stricter requirements than the Act. Case law, MOI must be consistent with the Act. Benthivime v. Benthivime. A company's articles cannot override an Act provision. A clause giving preference shareholders control over asset sales was invalid as it conflicted with S. 228 of the Companies Act, 1973. Permitted MOI provisions. Alterations to alterable provisions of the Act. Special conditions applicable to the company. Extra requirements for amending special conditions. Prohibitions on amending certain MOI provisions. Flexibility in MOI. Explanatory Memorandum, 2008, required provisions protect shareholders. Default rules can be accepted or modified. Companies cannot contract out of the Act's fundamental provisions, S. 6.1, Anti-Avoidance Rule. MOI can regulate company powers and restrictions, shareholder rights and resolutions, director elections, duties, and liabilities, board structure and governance, company dissolution rules, audit and financial requirements. Case law, right of shareholder to appoint a proxy. Berry v. Clearwater Estates NPC. MWA required proxies to be lodged 48 hours before meetings. Court ruled this void, as S58(1) gives shareholders the unalterable right to appoint a proxy at any time. _ 2.9.3 Rules made by the Board of Directors. The Board may make, amend, or repeal rules, unless the MWA states otherwise. S15(3). Rules must be published as per MWA requirements, filed with the Commission, if required, consistent with the Act and MWA. Any inconsistent rule is void. S15(4). Case law, rules must be consistent with the Act. Venturno v. Silver Lakes Homeowners Association NPC. A rule limited a member's right to appoint more than 5 proxies. Court ruled this void, as it restricted shareholder rights under S58(1). Effectiveness of rules. Takes effect 10 business days after publication unless a later date is specified. Interim binding status until ratified by shareholders. If rejected, the Board cannot reintroduce a similar rule for 12 months unless pre-approved by shareholders. _ 2.9.4 Legal status of the MWA and Board rules. The MWA and Board rules are legally binding. Between the company and shareholders, among shareholders, between the company and directors, between the company and prescribed officers or Board committee members. _ 2.9.5 Ring-fenced, RF, companies. RF, ring-fenced, designation, S11(3)(b), applies if the MWA contains restrictive conditions, extra procedural hurdles for amendments beyond S16 requirements. Significance of RF status. Third parties are presumed aware of MWA restrictions. The Turquoise rule does not apply, outsiders cannot assume compliance. Constructive notice doctrine, S19(5). If a company's name includes RF, third parties are deemed aware of special MWA provisions. S20. Generally, third parties can assume company compliance with formalities unless dealing with an RF company. Next page. 2.9.6 Amending the Memorandum of Incorporation, MOI. A company's MWA may be amended in the following ways. 1. Compliance with a court order. 2. Board amendments under S36(3) and 4. Relating to share structures. 3. Special resolution by shareholders, either proposed by the Board, or proposed by shareholders holding at least 10% of voting rights, and approved at a shareholders' meeting. _ 2.9.6.1 Amendment of MWA in compliance with a court order. Section 16(4). If a court orders an amendment, the Board must effect the change. No special resolution by shareholders is required. _ 2.9.6.2 Amendment of MWA by directors under Section 36(3) and 4. Section 36(3). Unless restricted by the MWA, the Board may increase or decrease the number of authorized shares, reclassify authorized but unissued shares, classify unclassified authorized shares, determine share preferences, rights, and limitations. Section 36(4). If the Board makes changes under S36(3), the company must file a notice of amendment with the Commission. _ 2.9.6.3 Amendment by special resolution of shareholders. A special resolution can replace the entire MWA, make specific alterations, including changing the company name, deleting, altering, or replacing existing provisions, inserting new provisions. If an amendment causes a profit company to no longer meet its current category, it must also change its name. Example, a private company, proprietary, limited with freely transferable shares must change to a public company, limited. _ 2.9.6.4 Effective date of MWA amendments. If the amendment changes the company's name, it takes effect on the date stated on the new registration certificate issued by the Commission. In all other cases, the amendment takes effect on the later of the date and time the notice of amendment is filed. The date specified in the notice of amendment. Section 16(7). The company must file a notice of amendment and pay the prescribed fee. The Commission may require a full copy of the amended MWA within a reasonable time. _ 2.9.6.5 Relevant sections of the Act for MWA amendments. Section 13(3) relates to restrictive conditions in an MWA that designate a company as an RF company. Section 13(4) (a) The Commission may reject an MWA if it is incomplete or improperly completed. Section 14 governs company registration and naming requirements. Section 13(2) (b) If a new MWA replaces the old one, it must accompany the amendment notice. If the MWA is only altered, The company must include a copy of the amendment. Sections 14(2) and 3 apply if the amendment includes a name change, specifying naming requirements and restrictions. Next page. 2.9.6.6 Nature of and prohibition of amendments. No general restrictions on what can be amended in an MWA, except if the MWA contains restrictive conditions, S 15(2)(b) and c. If an amendment attempts to alter an unalterable provision, except where it imposes a greater burden. Section 15 applies to both original MWA and amendments. Allows the MWA to include any provision not addressed by the Act. Permits the MWA to alter any alterable provision. Underscore 2.9.7 Alterations to correct errors in MWA and rules. The board or an authorized individual may alter the MWA or company rules to correct minor errors, for example, spelling, punctuation, reference, grammar. No special resolution is required. Instead, the company must publish a notice of the alteration. File a notice of the alteration. The method of publication must follow what is required or permitted by the MWA or company rules. Underscore 2.9.8 Translations of a Memorandum of Incorporation. A company may file a translated version of its MWA in any official language. The translation must include a sworn statement by the translator, certifying it as a true, accurate, and complete translation. If a conflict arises between a translated MWA and the original MWA prevails. Underscore 2.9.9 Consolidation of a Memorandum of Incorporation. After filing amendments to the MWA, a company may file a consolidated revision incorporating all amendments. The Commission may also require a company to file a consolidated revision. The consolidated MWA must be accompanied by a sworn statement by a director, or a statement by an attorney or notary public, confirming it is a true, accurate, and complete representation of the amended MWA. Underscore February 9, 2010 Authenticity of versions of the Memorandum of Incorporation. Conflicts between different versions of the MWA are resolved as follows. The amended MWA prevails over a translated MWA, S 18(1)(a). The amended MWA prevails over a consolidated revision unless the consolidated revision is ratified by a special resolution, S 18(1)(b). The latest Commission-endorsed version prevails over any other version of the MWA, S 18(2). Underscore February 9, 2011 Shareholders Agreement. Shareholders may enter into agreements regarding the company, but such agreements must comply with the Companies Act, 2008 and the MWA. Any inconsistent provision is void to the extent of the inconsistency, S 15(7). Key change from the Companies Act, 1973. Under the 1973 Act, a shareholders' agreement took precedence over the company's articles. Under the 2008 Act, the MWA takes precedence over a shareholders' agreement. Case study, Giwala v. Grancy Property Limited. A shareholders' agreement outside the MWA regulated how the company and its directors exercised their powers. The court ruled that such agreements are common in business and valid if they do not directly contradict the Act or the MWA. Examples of common provisions in such agreements. Rights of investors to appoint directors. Decisions requiring investor consent. Regulations on credit incurring and asset sales. Strategic decision-making constraints. The court upheld an agreement that qualified how general powers were exercised but did not directly contradict the Act or the MWA. Next page. February 9, 2012 Steps to incorporate a company. Profit company can be incorporated by one or more persons. Non-profit company requires 3 or more persons. Incorporation process. Each incorporator must complete and sign the MWA. A notice of incorporation must be filed with the Commission, along with the prescribed fee. A copy of the MWA, unless the standard MWA provided in the Companies Act, 2008 is used. Underscore February 9, 2013 The Commission's role in incorporation. Rejection of notice of incorporation. If incomplete or improperly completed, minor deviations from the prescribed form do not invalidate incorporation unless it materially affects the notice's substance. It reasonably misleads the reader. Compulsory rejection by the Commission. If the initial number of directors is fewer than the required minimum. If any proposed director is disqualified, leaving fewer than the minimum required directors. Underscore February 9, 2014 Registration of the company and registered office. Section 14 governs company registration. Upon acceptance of the notice of incorporation, the Commission assigns a unique registration number, records the company's details in the company's register, issues a registration certificate if all formalities are met. Legal significance of registration certificate. Conclusive evidence of incorporation compliance, establishes the company as a separate legal entity from the incorporation date. Registration certificate definition, S1, Companies Act, 2008. Post-2008 companies, issued by the Commission as evidence of incorporation. Pre-existing companies. Registered under the Companies Act, 1973 Certificate of Incorporation/Registration. Converted from Close Corporations Act, 1984 Certificate under Schedule 2 of the 2008 Act. Registered under any other law relevant incorporation document. External companies, certificate issued under Companies Act, 2008 or Companies Act, 1973. Section 23(3), Registered Office Requirements. Every company or external company must maintain at least one office in South Africa. Register the office address, or if multiple offices exist, the principal office. Initially, companies provide the address in the Notice of Incorporation. External companies provide the address during registration filing. Subsequent changes, file a notice of change with the prescribed fee. Case studies. Determining a company's place of business. Sibakulu Construction, Proprietary, Limited v. Wedgwood Village Golf Country Estate, Proprietary, Limited. Companies Act, 1973. Allowed companies to register any address as their official office, even if it was not an actual business location, for example, auditor's address. Key distinctions under the Companies Act, 2008. Registered office remains essential for public interaction with the company. The registered office must be either the only office of the company. If multiple offices exist, the principal office, not specifically defined in the Act, determined by where the company's general administration is conducted, equivalent to the principal place of business. Unlike the 1973 Act, the 2008 Act requires the registered office and the principal place of business to be at one and the same address. Pre-existing companies must update their registered office address if it does not match their principal place of business. S23(3)(b) ensures that third parties can easily locate and communicate with the company. The principal place of business is a question of fact. Payslip Investment Holdings CCVY2K Tech Limited. Walden Mar, Proprietary, Limited v. Intratrek Properties, Proprietary, Limited. Issue, whether service of a winding-up application was properly executed. Facts. Application was served at the company's principal place of business, Johannesburg. The registered address was in Nelspruit, outside the jurisdiction of the Johannesburg court. Respondent's argument. Service should only be at the registered office. If correct, the Johannesburg court would lack jurisdiction. Court's ruling. Companies Act, 1973, allowed service at either the registered office, or the main place of business. Companies Act, 2008. The registered office and principal place of business must be the same. Liquidation applications must be served at the registered office, which is now the same as the main place of business. Transitional provisions. Liquidations of insolvent companies are still governed by Chapter 14 of the Companies Act, 1973. Until transitional provisions are updated, winding-up applications can still be served at either the registered office or a principal place of business. Next page. 2.10 Pre-incorporation contracts. A company does not exist before incorporation and cannot perform juristic acts. No one can act as the company's agent before incorporation, as an agent cannot act for a non-existent principal. Section 21 of the Companies Act, 2008 allows pre-incorporation contracts under certain conditions. A pre-incorporation contract is a contract entered into by a person on behalf of a company that does not yet exist, intending that the company will be bound by it once incorporated. The person entering the contract is jointly and severally liable if the company is not incorporated or if the company rejects any part of the contract. Is not liable if the company, after incorporation, enters into an agreement on the same terms or substitutes the pre-incorporation contract. Once incorporated, the board of directors has 3 months to either ratify, completely, partially, or conditionally reject the contract. If no action is taken, the contract is deemed ratified. If the contract is ratified, the company is bound as if it had originally entered into the agreement. If rejected, the individual can recover any benefits the company received. Initially, the Companies Bill did not require pre-incorporation contracts to be in writing, but the Companies Act, 2008 now requires them to be written. Case study, Shell 271, Proprietary, Limited v. Uitshorn Municipality. A municipality awarded a tender to a company to be formed, NewCo. Shell, an existing company, sought to enforce the tender. The municipality cancelled the tender, arguing Shell was not the intended company. Court ruling. The tender was a pre-incorporation contract meant to be ratified by the new company. Shell was already in existence at the time of the tender submission. Mr. C submitted the tender on behalf of a company yet to be formed, NewCo, not Shell. Shell lacked locus standi to challenge the municipality's cancellation. _ 2.11 Registration of company names. Companies Act, 2008 restricts company names that offend race, ethnicity, gender, or religion. A company's name must comply with common law rules against passing off. Passing off occurs when a business adopts a competitor's trade name or distinguishing feature, can confuse consumers and divert business unfairly. Unlawful under common law. Case study, Peregrine Group, Proprietary, Limited v. Peregrine Holdings Limited. Applicants sought to force respondents to change their name due to passing off. Relief sought under S45(2)(a) of the Companies Act, 1973 and common law. Court ruling. To succeed, applicants had to prove likelihood of confusion, resulting damage. No secondary meaning for Peregrine was established. No confusion likely as businesses operated in different fields. Application dismissed. Case study, Aziza, Proprietary, Limited v. Aziza Media CC. Applicant, Aziza, Proprietary, Limited, was incorporated in 1993 and used the name Aziza in all business activities. Discovered Aziza Media CC, registered in 1998, had taken the name Aziza.com for its website. Court ruling. The full registered name Aziza Media CC was acceptable. However, the abbreviation Aziza could cause confusion and was thus undesirable. Aziza Media CC was prohibited from using the abbreviation Aziza. _ 2.11.1 Criteria for company names in terms of the Companies Act, 2008. Shift in regulation. Companies Act, 1973, registrar could reject names deemed undesirable. Companies Act, 2008, Commission cannot refuse company registration due to an undesirable name. Instead, if the name is prohibited or reserved for another entity, the company will be assigned its registration number as an interim name. Section 11(2) Restrictions. A company name must not be identical or confusingly similar to another registered company, close corporation, or cooperative. A registered business name under the Business Names Act. A trademark filed under the Trademarks Act. A company name must not falsely imply affiliation with another company. Government or international organization ownership, particular educational or regulatory status. Case study, Lucky Star Limited v. Lucky Brands, Proprietary, Limited. Appellant claimed the respondent's name was confusingly similar to its registered trademarks. Relief sought under S11(2)(b) and S11(2)(c). Court ruling. No likelihood of confusion or misleading association. Appeal dismissed with costs. Profit company names can use only their registration number, followed by South Africa. Non-profit companies cannot use only a registration number as their name. Names may include words from any language, letters, numbers, and specific symbols, plus, and, hash, at, percent, equals, round brackets, to isolate parts of the name. Table 2.2, Different types of companies and their name endings. Type of company name ending. Personal liability company incorporated or incorporated. Private company proprietary limited or proprietary, limited. Public company limited or limited. State-owned enterprise SOC limited. Non-profit company NPC. Ring-fenced RF. _ 2.11.2 Similar names. If a suggested name is too similar to another entity's name or trademark, the Commission may require the applicant to notify the affected party. Refer the case to the company's tribunal for determination. _ 2.11.3 Use of name and registration number. Section 32 Requirements. A company must provide its full registered name or registration number on demand. Misstating the name or number in a misleading manner is prohibited. If given an interim name, registration number, the company must use it until the name is amended. Case study, Epstein v. Bell. Company name, South African Unlisted Securities Market Exchange, Proprietary, Limited. Checks printed, SA Unlisted Secretary Market Exchange, Proprietary, Limited. Checks dishonored due to incorrect name usage. Court ruling. Abbreviations like SA for South African were not acceptable. A company must use its full registered name. Underscore. 2.11.4 Reservation of a name for later use. A person can reserve one or more names for a new company. Changing an existing company's name. The Commission must approve reservations, unless the name is already registered by another entity. The name has been reserved by someone else. Reservation period. 6 months from the application date. A reserved name can be transferred to another person via a signed notice of transfer. Next page. 2.12 The impact of the Companies Act, 2008 on the ultra vires and constructive notice doctrines. The ultra vires and constructive notice doctrines both relate to the validity of company actions based on its constitution. Historically, these doctrines were used to nullify unauthorized actions. The Companies Act, 2008 significantly limits their impact. Underscore. 2.12.1 The ultra vires doctrine. Definition. Ultra vires refers to acts beyond a company's powers as set out in its Memorandum of Incorporation, MOI. Historical development. If a company acted beyond its stated objectives, such acts were void and unenforceable. Example, a company that was authorized to manufacture railway wagons entered into a financing contract for railway construction. The court held the contract void. Purpose of the doctrine. Protect shareholders by ensuring company funds are used for stated purposes. Protect creditors by allowing them to assess risk based on company objectives. Company response. Drafting broad and extensive MOI clauses to encompass various business activities. Judicial developments. Courts narrowed the doctrine's application, distinguishing between acts done in abuse of power, enforceable unless third parties knew of the abuse. Acts genuinely beyond the company's powers, void under ultra vires. Consequences of ultra vires acts. Directors acting ultra vires could be held liable for breaching fiduciary duties. Shareholders could seek an interdict to prevent ultra vires actions. Case study, Quadrangle Investments, Proprietary, Limited v. Whitand Holdings Limited. The company's MOI prohibited using capital reserves for dividends. Despite this, the company declared a dividend from its capital reserve. Court ruling. The act was ultra vires and null and void. Even unanimous shareholder approval could not validate the action. Underscore. 2.12.2 Constructive notice. Definition. The doctrine of constructive notice states that anyone dealing with a company is deemed to know its MOI and other registered documents. Legal consequences. Third parties could be bound by ultra vires actions, as they were presumed to know company limitations. Tourquant rule, mitigating the doctrine's effects. If an action did not obviously contradict company documents, third parties could assume compliance with internal requirements. Accepted in South African law, third parties were protected unless a new and internal rule was not followed. Reasonably should have suspected non-compliance but failed to inquire. Underscore. 2.12.3 Ultra vires and the Companies Act, 2008. Key provisions. Section 21. A company's actions are not void solely because they exceed a limitation, restriction, or qualification in the MOI. Section 22. Shareholders may ratify ultra vires actions through a special resolution. Section 24 and 5. A shareholder, director, or prescribed officer can seek an order to restrain ultra vires actions. However, this does not prevent third parties from suing for damages, unless they had actual knowledge of the limitation. Section 27. A person dealing with a company in good faith can assume compliance with legal and procedural requirements unless they knew or ought to have known of non-compliance. Effect. The Companies Act largely abolishes ultra vires as a defense against third parties acting in good faith. Only actual knowledge of a restriction, not suspicion, bars a claim. Underscore. 2.12.4 Abolition of the doctrine of constructive notice. Section 19 of the Companies Act, 2008. Eliminates the presumption that third parties must verify company documents before contracting. Exception, Section 19.5, read with Sections 15.2b and c. A third party is deemed to have knowledge of MOI restrictions if the Notice of Incorporation prominently highlights these restrictions, per Section 13.3. The company name includes RF, ring-fenced, to indicate restrictions. Effect. Companies with restrictive MOIs must include RF in their name. Clearly highlight restrictions in the Notice of Incorporation. Third parties are only bound by restrictions if properly informed. Next page. 2.12 The impact of the Companies Act, 2008 on the ultra vires and constructive notice doctrines. The ultra vires and constructive notice doctrines historically nullified unauthorized actions by companies. The Companies Act, 2008 has significantly reduced their impact. 2.12.1 The ultra vires doctrine refers to actions beyond a company's powers as stated in its Memorandum of Incorporation, MOI, originated to protect shareholders, ensuring funds were used as intended, creditors, assessing company risk through stated objectives. Companies circumvented the doctrine by drafting broad objects clauses. English courts limited its application. Acts within a company's express power but used for an improper purpose were not ultra vires but voidable if the third party had notice. Directors could be held liable for fiduciary breaches if they engaged in ultra vires actions. Shareholders could seek an interdict against ultra vires actions. Case study: Quadrangle Investments, Proprietary, Limited v. Wood & Holdings Limited. A company's memorandum prohibited capital reserves from being used for dividends. The company declared such a dividend, which the court deemed ultra vires and void, even with unanimous shareholder approval. 2.12.2 Constructive Notice. Doctrine states third parties are deemed to know a company's MOI and internal rules could lead to contracts being void if a company acted ultra vires. Tourquand rule, English case law, mitigated this by protecting third parties unaware of internal non-compliance. Adopted into South African law, third parties unaffected unless they knew or reasonably should have known of the internal breach. 2.12.3 Ultra vires and the Companies Act, 2008. Section 21, no company action is void solely due to an MOI limitation. Section 22, shareholders may ratify actions breaching the MOI via special resolution. Section 24 and 5, shareholders, directors, or officers can restrain a company from breaching the act or MOI. Third-party protection can claim damages unless they had actual knowledge of the breach. Section 27, a third party in good faith may assume compliance unless they knew or ought to have known otherwise. 2.12.4 The abolition of constructive notice. Section 19(1), third parties are no longer required to check a company's registered documents. Exception, Section 19(5). If restrictive provisions are explicitly noted in compliance with Section 13(3). The MOI must include a prominent statement about restrictions. The company name must include RF, ring-fenced, to warn third parties. Companies with restrictions must ensure compliance with these notice requirements. Chapter 3, Groups of Companies. 3.1 What is a group of companies? Juristic entity, a separate legal person, for example, a company. Economic entity, a group of companies acting together, controlled by a holding company. A holding company controls one or more subsidiary companies. Control allows coordinated management, but each company remains a separate legal entity. Directors owe fiduciary duties to their own company and cannot sacrifice its interests for the group. Legal, accounting, and practical consequences arise from group structures. Example, the Bidvest Group Limited. A South African investment holding company with over 300 subsidiaries. Key sectors include 1. Travel, food, and aviation. 2. Freight. 3. Office and print. 4. Automotive. 5. Financial services. 6. Commercial products. 7. Electrical and commercial. 3.2 Definitions. Section 1 of the Companies Act, 2008. Group of companies, two or more companies in a holding subsidiary relationship. Holding company, a juristic person controlling a subsidiary. Subsidiary company, a company controlled by another. Control arises through 1. Majority voting rights at general meetings. 2. Board control via director appointments. 3. Contractual control, such as a shareholders' agreement. 3.3 Why would a group of companies be formed? Diversification, holding various businesses under one structure. Risk limitation, subsidiaries maintain separate liability. Centralized control, efficient management, cost savings, and operating efficiency. Financial structuring, holding companies finance subsidiaries. Acquisitions and expansion, acquiring new businesses via shareholding. Outside investment, allows minority shareholders to invest in a subsidiary. Case study, Ex parte Gore and others NNO, Piercing the Corporate Veil, a court disregarded separate legal personality. Reason, the group treated its companies as one, moving funds without legal distinction. Court ruling, investors could sue the holding company, Bypassing subsidiaries. Risk example, Techitown and Steinhoff. Techitown was acquired by Steinhoff in exchange for shares. Steinhoff collapsed, leaving Techitown sellers with worthless shares. Sellers sought court intervention to reverse the sale, but outcome uncertain. Underscore. These summaries maintain in-depth legal analysis while being structured in a clear, concise format. Let me know if you need further refinements. Next page. Chapter 3, Groups of Companies. 3.1 What is a group of companies? A juristic entity is a separate legal person, for example, company, close corporation. An economic entity consists of multiple companies controlled by a single holding company. A group of companies refers to a holding company and its subsidiaries. Control enables a group to function as an economic unit, though each company remains a separate legal entity. Directors owe fiduciary duties to their specific company, even within a group structure. Legal, accounting, and practical consequences arise from the holding subsidiary relationship. Example, the Bidvest Group Limited operates as an investment holding company with over 300 subsidiaries across 7 business sectors. 3.2 Definitions. Companies Act, 2008, a group of companies, 2 or more companies that share a holding company or subsidiary relationship. A holding company, a juristic person or undertaking that controls a subsidiary. A subsidiary company, a company under the control of another company. Control arises if 1. The holding company has a majority of voting rights in the subsidiary. 2. The holding company can control the board of directors. 3. Control may also exist through contractual arrangements, such as a shareholder agreement. 3.3 Why would a group of companies be formed? Diversification and expansion enables different businesses to operate within one corporate group. Risk reduction. Each company remains a separate juristic entity, limiting liability exposure. Centralized control and efficiency reduces duplication of functions and improves management. Financing and restructuring. Holding companies finance subsidiaries and facilitate acquisitions. Flexible ownership allows outside shareholders to invest in subsidiaries. Case study, separate juristic personality and piercing the corporate veil. In Ex parte Gore and others NNO, the court pierced the corporate veil under S29 of the Companies Act, 2008, due to the group's failure to maintain separate legal identities. Creditors could claim against the holding company, rather than being limited to the specific subsidiary. Risk example, Techitown and Steinhoff case. Techitown's owner sold shares to Steinhoff in exchange for shares in the holding company. When Steinhoff's share price collapsed due to financial irregularities, the Techitown sellers suffered severe financial losses. Underscore. 3.4 Definition of a holding and subsidiary company in more detail. 3.4.1 Definition of control. Companies Act, 2008, S22A. A company, H, controls another company, S, if S is a subsidiary of H. H, alone or with related persons, can control a majority of voting rights in S, directly or indirectly. H has the right to appoint or elect a majority of the directors who control board decisions. H can materially influence S's policy. 3.4.2 Meaning of controlling the general voting rights. S32, voting rights exercisable only in certain circumstances count only when those circumstances arise. Voting rights exercised with another's consent count as if held by that person. Shares held in trust count as if held by the beneficiary. Control is determined by voting power, not the number of shares held. 3.4.3 Definition of related or interrelated. S21, related persons, 2 entities linked under S21A, C. Interrelated persons, 3 or more entities connected in a chain under S21. A juristic person is related to another if 1. One directly or indirectly controls the other. 2. One is a subsidiary of the other. 3. A third person controls both entities. 3.4.4 Definition of subsidiary company. S31 A company is a subsidiary if 1. A holding company, or its subsidiaries/nominees, can control a majority of voting rights in the company. 2. The holding company has the right to appoint directors who control board decisions. 3. A wholly owned subsidiary exists where all voting rights are held by the holding company or related persons. Notable point. The Companies Act, 2008 recognizes a trust as a juristic person, meaning a trust can be a holding company. This was not possible under the Companies Act, 1973. Next page. 3.4 Definition of a holding and a subsidiary company. Holding company, a juristic person or undertaking that controls a subsidiary. Subsidiary company, a company controlled by a holding company. 3.4.1 Definition of control, Section 2.2a A company, H, controls another company, S, if S is a subsidiary of H, with related/interrelated persons, can exercise/control a majority of voting rights in S. H has the right to appoint/elect or control the appointment of directors in S, who hold the majority of board votes. H has the ability to materially influence the policy of S. 3.4.2 Controlling the general voting rights, Section 3.2 for control determination. Voting rights exercisable only in certain circumstances are considered only when circumstances arise and continue, or the controlling person controls the circumstances. Voting rights requiring another person's consent are treated as held by that person. Voting rights held by a nominee or fiduciary are treated as belonging to the actual beneficiary. Control is determined by voting power, not shareholding numbers. 3.4.3 Definition of related or interrelated, Section 2.1, Related persons, connected as per Section 2.1a, c. Interrelated persons, three or more persons linked in a series of relationships under Section 2.1. A juristic person is related to another if one controls the other, one is a subsidiary of the other, or a common person controls both. 3.4.4 Definition of subsidiary company, Section 3.1 A company is a subsidiary if another juristic person, or its subsidiaries/nominees, can control a majority of general voting rights in the company. Appoint/elect directors who hold majority board votes. Wholly owned subsidiary, all voting rights belong to a holding company or its subsidiaries. A trust can be a holding company, which was not possible under the Companies Act, 1973. 3.5 Groups and annual financial statements. No specific requirement for consolidated financial statements in the Companies Act, 2008. IFRS application. If a company follows IFRS, consolidated statements are required. Private companies with a public interest score below 100 and internally compiled financials are exempt. Annual financial statements must include directors' report on the company/group's state of affairs, material matters for shareholders, prescribed information, disclosure of directors' remuneration is required. 3.6 Legal consequences for groups of companies. Though a group lacks separate legal personality, acts of one company may impact the group. Prevents abuse such as misuse of subsidiary funds through loans to directors, using subsidiary funds to buy shares in the holding company. 3.6.1 Acquisition of shares by a subsidiary in its holding company, Section 48.2. A subsidiary can acquire up to 10% of its holding company's issued shares per class. All subsidiaries combined cannot hold more than 10%. Directors approving an acquisition beyond 10% can be held liable for losses. Purpose: prevent abuse of voting rights and speculative trading. 3.6.2 Directors' conduct, Section 76. Directors cannot use their position/information to gain an advantage for themselves or others, except for the company, its holding company, or subsidiaries. Directors cannot knowingly cause harm to the company or its subsidiaries. Fiduciary duties of a director in a subsidiary are limited. 3.6.3 Share offerings to employees, Sections 95, 101, Employee Share Scheme, includes employees of subsidiaries. Secondary offering of shares, treated as if shares belong to a group. 3.6.4 Disposal of assets or undertaking, Sections 112, 115, General Rule. A special resolution by shareholders is required if a company disposes of most of its assets. Exemptions, Section 112, no resolution needed if disposal occurs between a wholly owned subsidiary and its holding company, between wholly owned subsidiaries of the same holding company, if disposal occurs between a not wholly owned subsidiary and its holding company. Special resolutions are required from both the subsidiary and holding company shareholders. 3.6.5 Financial assistance, purchase of shares, Section 44. A company may provide financial assistance for securities purchases only if 1. The board confirms the company meets the solvency and liquidity test. 2. Shareholders approve via special resolution. 3. Assistance terms are fair and reasonable. 4. More requirements are met. Non-compliance, financial assistance is void, and directors may be personally liable. Section 77(3)(e), 4. 3.6.6 Financial Assistance, Intercompany Loans and Director Loans, Section 45, applies to financial assistance within a group and loans to directors. A company may assist a related/interrelated company or director only if 1. Shareholders approve via special resolution, valid for 2 years. 2. Board confirms solvency and liquidity test is met. 3. More conditions, if any, are met. Written notice of financial assistance must be given if it exceeds 0.1% of company's net value. Non-compliance, court may declare the resolution void, and directors may be personally liable. Prevents abuse where subsidiaries are forced to loan money to group directors. 3.7 Groups and the lifting, piercing, of the corporate veil. Courts may ignore a company's separate legal personality in some cases. Section 29 of the Companies Act, 2008 supplements common law principles. In a group structure, the corporate veil may be pierced if a group operates as a single entity with no distinction between subsidiaries. Investors' funds are indiscriminately moved between entities. Case, ex parte Gore. Investors were misled into thinking they were investing in separate entities, but funds were randomly shifted. Court applied Section 29 and treated the group as a single entity. Investors could lodge claims against the holding company directly. Conclusion: courts can hold an entire group liable if it is treated as a single economic entity. Next page, Chapter 4, Corporate Finance. 4.1 Introduction to Corporate Finance. Corporate finance involves strategic, financing, and investment decisions by directors. Key considerations: acquisition and disposal of assets, financing of assets under directors' control, utilization and investment of assets. The Companies Act, 2008, impacts directors' corporate finance decisions, such as issuing shares for expansion. Two main sources of funding: debt, borrowing from external sources; equity, issuing shares or using retained income. The Act applies to both shares and debt instruments, securities. Definition of securities, Section 1, includes shares, debentures, and other instruments issued by a profit company. 4.1.1 Debt. A company can raise capital through debt by issuing debentures or taking out loans. Debt financing does not dilute ownership but creates financial obligations. 4.1.2 Equity. Equity financing involves raising funds by issuing shares or retaining earnings. 4.1.2.1 Shares. Companies can issue shares to investors to raise capital. Different classes of shares may have varying rights and obligations. 4.1.2.2 Retained income. Profits that are reinvested in the company rather than distributed as dividends. Provides internal funding without additional debt or dilution of ownership. 4.2 Sources of finance, nature of assets, and the solvency and liquidity test. Companies obtain financing through equity and debt based on their asset structure. The solvency and liquidity test ensures financial stability before transactions. 4.3 A new approach to capital regulation in the Companies Act, 2008. 4.3.1 Capital Maintenance. Companies Act shifts from a capital maintenance rule to a solvency and liquidity test. Focuses on whether a company can meet obligations rather than maintaining a fixed capital amount. 4.3.2 Default powers of directors. Directors have discretion in financial decisions, provided they comply with solvency and liquidity requirements. 4.4 The application of the solvency and liquidity test required before certain transactions such as share buybacks and distributions. 4.4.1 Solvency. A company is solvent if assets exceed liabilities. 4.4.2 Liquidity. A company is liquid if it can meet its short-term obligations. 4.5 Shares as a source of finance and the nature of shares. Shares provide long-term financing without repayment obligations. Rights and obligations vary depending on share classes. 4.6 Authorized, issued, and unissued shares. 4.6.1 Authorized shares and the Memorandum of Incorporation, MOI. The MOI determines the number and classification of authorized shares. 4.6.2 Entrenched rights attaching to authorized shares. Certain rights of shareholders are protected under the Act. 4.6.2.1 Right to vote on proposals to amend rights. Shareholders must approve changes to share rights. 4.6.2.2 Right to seek relief from material and adverse changes. Shareholders can challenge decisions that negatively affect their rights. 4.6.2.3 Rights. When there is only one class of shares. When a company has only one class of shares, all shares have equal rights. 4.6.3 Changes to authorized shares. Companies can amend the number or type of authorized shares through shareholder approval. Underscore 4.7 Issued shares. 4.7.1 Consideration for issued shares. Shares may be issued for cash or other valuable consideration. 4.7.2 Issue of shares for future payments or services. Companies can issue shares in exchange for services or future payments. 4.7.3 Issue of capitalization shares. Shares issued as a dividend instead of cash payments. 4.7.4 When shareholder approval is required to issue shares. 4.7.4.1 Issue of shares to directors and related parties requires shareholder approval to prevent conflicts of interest. 4.7.4.2 Issue of shares when voting power will be 30% or more. Shareholder approval required when a new issue significantly impacts voting control. 4.7.5 Preemptive rights. Existing shareholders have the right to buy new shares before external investors. 4.7.6 Financial assistance. Companies providing financial assistance for share purchases must meet legal requirements. 4.7.7 Certificated and uncertificated securities. Securities can exist in paper, certificated, or electronic, uncertificated, form. 4.7.8 Records of issued shares. Companies must maintain a securities register with details of all issued shares. Underscore 4.8 Unissued shares. Shares that are authorized but not yet issued. Directors may issue these shares within the constraints of the MOA. Underscore 4.9 Distributions. 4.9.1 Requirements preceding any distribution. Distributions, dividends, buybacks, etc., must pass the solvency and liquidity test. 4.9.2 Share buybacks. Companies can repurchase their own shares under certain conditions. 4.9.3 Cash in lieu of capitalization shares. Shareholders may receive cash instead of additional shares. Underscore 4.10 Debt instruments. Debt instruments, debentures, bonds, loans, provide financing without ownership dilution. Companies must comply with legal requirements when issuing debt securities. Underscore relevant sections of the Companies Act, 2008 and Securities Section. Topic 42 Options for subscription of securities. 43 Securities other than shares. 44 Financial assistance for subscription of securities. 49 Securities to be evidenced by certificates or uncertificated. 50 Securities register and numbering. 51 Registration and transfer of certificated securities. 52 Registration of uncertificated securities. 53 Transfer of uncertificated securities. 54 Substitution of certificated or uncertificated securities. 55 Liability relating to uncertificated securities. 56 Beneficial interest in securities. This completes the summary for Chapter 4. Let me know if you need any modifications. Next page. Chapter 4, Corporate Finance. 4.1 Introduction to Corporate Finance. Corporate finance involves decisions related to financing, investment, and asset management. Directors determine what assets to acquire or dispose of, how assets are financed, how assets are invested or utilized. The Companies Act, 2008 regulates corporate finance decisions, including share issuance, sources of financing, debt and equity. Section 1 of the Act defines securities as shares, debentures, or other instruments issued by a profit company. Key sections of the Companies Act, 2008 related to securities. Section Topic 42 Options for subscription of securities. 43 Securities other than shares. 44 Financial assistance for subscription of securities. 49 Securities to be evidenced by certificates or uncertificated. 50 Securities register and numbering. 51 Registration and transfer of certificated securities. 52 Registration of uncertificated securities. 53 Transfer of uncertificated securities. 54 Substitution of certificated or uncertificated securities. 55 Liability relating to uncertificated securities. 56 Beneficial interest in securities. Underscore 4.1.1 Debt. Debt is funding obtained through issuance of debt instruments, for example, debentures, long-term or short-term loans, lease agreements, supplier credit terms, delayed payment for goods/services, bank overdraft facilities. Legal implications of debt. The Companies Act, 2008 regulates debt instruments and prohibits reckless trading. Directors may be personally liable if excessive debt is incurred recklessly. Case law on reckless debt incurrence. Osinski Novi Lloyd, incurring debts without a reasonable prospect of repayment is reckless. Bellini v. Paulson, fraudulent management occurs when a director knowingly continues operations despite insolvency. Underscore. 4.1.2 Equity. Equity includes 1. Shares. 2. Retained income. 4.1.2.1 Shares. Companies raise funds by issuing shares. Shares may be of the same class or different classes with varying rights. Share issuance can impact existing shareholders by diluting their interest unless they participate in a rights issue. Shareholders have fewer rights than creditors in business rescue proceedings. Section 22(2). If a company cannot pay its debts, the company's commission may intervene. Case law on shareholder rights. Itsikowitz v. Absa Bank Limited. A company is separate from its shareholders. Company property belongs to the company, not shareholders. Shareholders only have a right to participation in the company's assets upon winding up. Shareholders cannot claim damages for company losses. 4.1.2.2 Retained income. Profits not distributed as dividends but retained for future investments. Dividend policies impact company financing and shareholder returns. Directors' duties. Must apply retained profits effectively. Must ensure solvency and liquidity before dividend payments. Key sections of the Companies Act related to distributions. Topic relevant section. Dividend declarations Section 46. Share buybacks Section 48. Payment of cash instead of issuing capitalization shares Section 47. Underscore. 4.2 Sources of finance, nature of assets, and the solvency and liquidity test. Sources of finance, debt versus equity. Solvency and liquidity test ensures a company can meet its obligations before transactions. Underscore. 4.3 A new approach to capital regulation in the Companies Act, 2008. 4.3.1 Capital maintenance. Focuses on ensuring that a company has sufficient capital to meet obligations. 4.3.2 Default powers of directors. Directors have powers to manage capital but are subject to statutory limitations. Underscore. 4.4 Application of the solvency and liquidity test. 4.4.1 Solvency. A company is solvent if its total assets exceed total liabilities. 4.4.2 Liquidity. A company is liquid if it can pay debts as they fall due. Underscore. 4.5 Shares as a source of finance and the nature of shares. Shares are key to corporate financing and dictate shareholder rights. Underscore. 4.6 Authorized, issued, and unissued shares. 4.6.1 Authorized shares and the Memorandum of Incorporation, MOI, MOI outlines authorized share structure. 4.6.2 Entrenched rights attaching to authorized shares. Right to vote on amendments to share rights. Right to seek relief if share rights are materially altered. Rights when only one class of shares exists. 4.6.3 Changes to authorized shares. Section 36 regulates changes to share authorization. Underscore. 4.7 Issued shares. 4.7.1 Consideration for issued shares. Shares must be issued for adequate consideration. Section 40. 4.7.2 Issue of shares for future payments or services. Future payments allowed under Section 45. 4.7.3 Issue of capitalization shares. Capitalization shares issued under Section 47. 4.7.4 When shareholder approval is required. Issue of shares to directors or related parties, Section 41. Issue of shares giving 30% or more voting power. 4.7.5 Preemptive rights. Section 39. Existing shareholders may have the right to first purchase newly issued shares. 4.7.6 Financial assistance. Section 44. Regulates financial assistance for share subscriptions. 4.7.7 Certificated and uncertificated securities. Sections 24 and 26 regulate the form and records of securities. 4.7.8 Records of issued shares. Securities register must be maintained under Section 44. Underscore. 4.8 Unissued shares. Unissued shares remain under company control until formally issued. Underscore. 4.9 Distributions. 4.9.1 Requirements preceding any distribution. Section 46 requires a solvency and liquidity test before distribution. 4.9.2 Share buybacks. Section 48 allows companies to repurchase their own shares under conditions. 4.9.3 Cash in lieu of capitalization shares. Section 47 Companies may pay cash instead of issuing capitalization shares. Underscore. 4.10 Debt instruments. Section 43 regulates non-share securities, for example, debentures. Underscore. Summary of funding sources in the Companies Act, 2008. Topic relevant section. Shares as Finance Section 35. More content on authorized shares Sections 36 to 37. Issued shares Section 38. Consideration for issued shares Section 40. Shareholder approval Section 41. Preemptive rights Section 39. Financial assistance Section 44. Records of securities Section 44. Distributions, dividends, buybacks, etc., Sections 46 to 48. Debt instruments Section 43. This chapter comprehensively covers debt and equity financing, regulations on shares, solvency and liquidity requirements, and shareholder rights. Next page. Study Notes, Corporate Finance and Company Law, Chapter 4 4.1 Introduction to Corporate Finance. Corporate finance involves strategic, financing, and investment decisions. Directors must determine what assets to acquire and dispose of, how assets should be financed, how assets should be invested or utilized. The Companies Act, 2008 imposes legal requirements on corporate finance decisions, for example, share issuance. Funding decisions are based on business nature and location, type of assets required, capital intensity and cash flow needs. Two main sources of funding, debt and equity. The Act defines securities as shares, debentures, or other instruments issued by a company. Key sections of the Companies Act, 2008 on securities. Section Topic. 42 Options for subscription of securities. 43 Securities other than shares. 44 Financial assistance for subscription of securities. 49 Securities to be evidenced by certificates or uncertificated. 50 Securities register and numbering. 51 Registration and transfer of certificated securities. 52 Registration of uncertificated securities. 53 Transfer of uncertificated securities. 54 Substitution of certificated or uncertificated securities. 55 Liability relating to uncertificated securities. 56 Beneficial interest in securities. Underscore. 4.1.1 Debt. Debt refers to money/assets obtained by a company through debt instruments, for example, debentures, loans, short-term and long-term, lease agreements, credit terms from suppliers, deferred payment for goods/services, overdraft facilities from banks. Regulatory considerations. Companies Act, 2008 explicitly deals with debt instruments, for example, debentures. Other debt-related provisions. Prohibition on reckless trading, director duties and liabilities if debt financing risks company solvency. Case law on reckless debt incurrence. Osinski Novi Lloyd. If a company incurs debts with no reasonable prospect of repayment, this indicates reckless trading. Bellini v. Paulson. Incurring debt despite knowing the company cannot repay constitutes fraudulent and reckless management. Underscore. 4.1.2 Equity. Equity financing consists of 1. Shares. 2. Retained income. 4.1.2.1 Shares. Companies finance operations by issuing shares. Share issuance impacts existing shareholders, for example, dilution versus rights issues. Companies Act, 2008 distinguishes. Next page. Study Notes, Corporate Finance and Company Law, Chapter 4 4.1 Introduction to Corporate Finance. Corporate finance involves strategic, financing, and investment decisions, including acquisition and disposal of assets, financing of assets, utilization and investment of assets. The Companies Act, 2008 regulates corporate finance decisions, for example, share issuance, financial assistance. Two main funding sources, debt and equity. Securities include shares, debentures, and other instruments issued by a company. Companies Act, 2008, Section 1. Key sections of the Companies Act, 2008 on securities. Section Topic. 42 Options for subscription of securities. 43 Securities other than shares. 44 Financial assistance for subscription of securities. 49 Securities to be evidenced by certificates or uncertificated. 50 Securities register and numbering. 51 Registration and transfer of certificated securities. 52 Registration of uncertificated securities. 53 Transfer of uncertificated securities. 54 Substitution of certificated or uncertificated securities. 55 Liability relating to uncertificated securities. 56 Beneficial interest in securities. Underscore. 4.1.1 Debt. Debt refers to money or assets obtained by a company through issuing debt instruments, for example, debentures, long-term and short-term loans, lease agreements, credit terms from suppliers, delayed payment for received goods/services, overdraft facilities from banks. Regulatory considerations. Companies Act, 2008 explicitly addresses debt instruments. Other debt-related provisions. Prohibition on reckless trading. Directors cannot incur debt irresponsibly. Director duties and liabilities when financing decisions jeopardize solvency. Case law on reckless debt incurrence. Osinski Novi Lloyd. If a company continues to operate and incur debts without a reasonable prospect of repayment, this is reckless trading. Bellini v. Paulson. A director who incurs debt knowing the company cannot repay engages in fraudulent and reckless management. Underscore. 4.1.2 Equity. Equity consists of 1. Shares. 2. Retained income. 4.1.2.1 Shares. Companies fund operations by issuing shares. Share issuance impacts existing shareholders. Rights issue. Existing shareholders invest more to prevent dilution. External issuance. New investors receive shares, diluting existing shareholding. The Companies Act, 2008 differentiates shareholders' rights from creditors' rights. Creditors have stronger claims in business rescue proceedings. Solvency and liquidity tests protect creditors before major transactions. Section 22(2) allows the Commission to investigate companies unable to pay debts. Key legal principles on shareholder rights. Itzikowitz v. Absa Bank Limited. A company has a separate legal personality from its shareholders. Company property belongs to the company, not shareholders. Shareholders can only claim assets upon winding up. After creditors, shareholders cannot claim personal losses for company losses. 4.1.2.2 Retained income. Retained income forms part of a company's equity financing. Dividend policy affects corporate finance. Profits can be distributed as dividends or retained for reinvestment. Directors must ensure retained funds generate greater value than distributed funds. Legal duties of directors. Act diligently and skillfully in managing retained earnings. Ensure the company remains solvent and liquid after dividend payments. See Section 4.2. Companies Act, 2008 Provisions on Distributions. Section 47, Capitalization Shares, cash paid instead of issuing shares. Section 48, Share buybacks. Underscore. Table 4.2, Sources of funding, equity and debt instruments. Topic paragraph Relevant section of Companies Act, 2008. Equity, shares and distributions. Shares as a source of finance, the nature of shares 4.5 Section 35. Authorized shares. Useful disclosure? 4.6. Content of MWA 4.6.1 Sections 36 to 37. Unalterable provisions 4.6.2 Section 37. Changing authorized shares 4.6.3 Section 36. Issued shares. Introduction 4.7 Section 38. Consideration 4.7.1 Section 40. Future payments 4.7.2 Section 45 Capitalization shares 4.7.3 Section 47. When shareholder approval is required 4.7.4 Section 49. Preemptive rights 4.7.5 Section 39. Financial assistance for share subscription 4.7.6 Section 41. Certificated and uncertificated shares 4.7.7 Sections 24 and 26. Securities Register and Access 4.7.8 Section 44. Unissued shares 4.8. Distributions. Introduction 4.9. Requirements preceding distributions 4.9.1 Section 46. Share buybacks 4.9.2 Section 48. Cash in lieu of capitalization shares 4.9.3 Section 47. Debt instruments. Securities other than shares, for example, debt instruments, 4.10 Section 43. Underscore. This study note provides a structured summary of corporate finance under company law, focusing on debt and equity financing within the Companies Act, 2008 framework. Let me know if you need modifications or additional sections. Next. Page 4.2 Sources of finance, nature of assets, and the solvency and liquidity test. The Companies Act, 2008 introduced a solvency and liquidity test that must be applied before certain transactions occur. Directors must apply this test before declaring dividends, repurchasing company shares. The test affects corporate finance decisions, including choosing between debt and equity financing to ensure the company does not fail the solvency test, debts exceeding assets, or liquidity test, inability to meet payments. Key consideration: a company may be solvent, assets exceed liabilities, but still fail the liquidity test if assets are illiquid. Definition: a company passes the solvency and liquidity test if, considering foreseeable financial circumstances, its fairly valued assets exceed fairly valued liabilities. It can pay its debts as they become due for 12 months after the test date. 4.3 A new approach to capital regulation in the Companies Act, 2008. 4.3.1 Capital maintenance. The Companies Act, 1973 followed the capital maintenance concept, ensuring contributed share capital was preserved to protect creditors. The Companies Act, 2008 abolished this concept, replacing it with a solvency and liquidity-based regime. Before a company can repurchase its shares, S-48, provide financial assistance for share subscription, S-44, propose a distribution, S-46, it must pass the solvency and liquidity test. The Act also removes the term share capital, referring instead to authorized and issued shares. The new regime better protects creditors than capital maintenance rules, as companies with large shareholder loans would often be deemed insolvent and restricted from certain transactions. 4.3.2 Default powers of directors. The Companies Act, 2008 introduces default provisions allowing directors, not shareholders, to determine authorized and issued shares, declare dividends, concerns for minority shareholders. Directors' unilateral power to issue shares may lead to dilution. Companies with diverse shareholders may modify or abolish these default provisions in the MOA. Under the Companies Act, 1973, changes to authorized shares required authorization in the Articles. Special shareholder resolution. The Companies Act, 2008 significantly alters this approach. 4.4 Application of the solvency and liquidity test must be applied in cases such as providing financial assistance for securities, S-44, granting loan/financial assistance to directors, S-45, declaring dividends or distributions, S-46, paying cash instead of capitalization shares, S-47, acquiring own shares, S-48, amalgamations and mergers, S-113. Key requirements: the company must be solvent and liquid immediately after the transaction and for the next 12 months. For dividends, the test applies twice: when the dividend is declared, when the dividend is paid. 4.4.1 Solvency. Defined in S4 of the Companies Act, 2008. Solvency: assets fairly valued must equal or exceed liabilities fairly valued. Directors must consider all assets and liabilities at fair value. Contingent liabilities. Intellectual property. Reducing liability value. Directors can adjust loan values, for example, impairing shareholders' loans, to meet the test. Subordinating shareholders' loans does not reduce company liabilities. In business rescue, subordinating loans reduces voting interest, impacting restructuring decisions. 4.4.2 Liquidity. Liquidity: the company's ability to pay debts as they fall due. Commercial solvency. Directors must prepare a cash flow statement assessing debt levels, cash availability for due payments. 4.5 Shares as a source of finance and the nature of shares. Definition: Companies Act, 2008, S1. A share is a unit of proprietary interest in a profit company. Shareholders do not own company assets, the company, as a separate entity, owns them. Legal nature: Cooper v. Boyce No. A share is an incorporeal movable property. It represents a bundle of personal rights. All shares in a class must have equal rights. Different rights create different share classes. Securities includes shares, debentures, and other financial instruments. Issuance considerations: companies must balance between equity financing and debt financing. Overcapitalization: issued capital exceeds the business earning capacity, reducing returns. Undercapitalization: insufficient capital restricts growth, expansion, and credit extension. Factors in determining share issuance: nature of the business, risk appetite, Debt versus equity funding, capital infrastructure needs, working capital requirements, availability of borrowing options. Next page. 4.6 Authorized, issued, and unissued shares. 4.6.1 Authorized shares and the Memorandum of Incorporation, MOI, Section 36 of the Companies Act, 2008, a company's MOI must specify classes of shares, number of shares in each class. Difference from Companies Act, 1973, no longer par value or no par value shares, only shares of different classes. The value of issued shares is not determined in the MOI. Authorized shares can be increased or decreased. If a company issues shares beyond authorized limits, the issue can be retroactively authorized by Board Resolution, S36, special resolution by shareholders within 60 business days. Common classes of authorized shares. Ordinary shares. Preference shares, which may be cumulative or non-cumulative. Participating. Redeemable. Convertible. Unclassified shares, can be classified by the Board, S36(3)(c). Blank shares, preferences, rights, and limitations are determined later by the Board before issuance. MOI provisions regarding share classes, S37(5) and S37(6), preferences, rights, limitations, or terms may confer special, conditional, or limited voting rights, provide for shares to be redeemable or convertible, define dividend entitlements, cumulative, non-cumulative, or partially cumulative, give certain shares preference over others for distributions or liquidation proceeds. Section 37(6), rights and limitations may be variable based on an objectively ascertainable external fact. 4.6.2 Entrenched rights attaching to authorized shares. 4.6.2.1 Right to vote on amendments, S37(3)(a). Every issued share has an irrevocable right to vote on any proposal to amend its rights. 4.6.2.2 Right to seek relief for adverse amendments, S37(8). Shareholders can seek relief under S164 if they oppose the amendment to the MOI. They voted against it at the meeting. Appraisal rights, S164, allows shareholders to demand fair value compensation for shares. 4.6.2.3 Rights when there is only one class of shares, S37(3)(b), the single class of shares has voting rights on every matter requiring shareholder approval. Entitlement to net assets upon liquidation. 4.6.3 Changes to authorized shares. Unless restricted by the MOI, the Board may increase or decrease the number of authorized shares. Reclassify authorized but unissued shares. Classify unclassified shares. Determine preferences, rights, and limitations of shares, S36(1)(d). If the MOI prohibits Board discretion, shareholder approval is required. Underscore. 4.7 Issued shares. Issued shares, shares that have been allocated to shareholders. Under Companies Act, 1973, directors required shareholder approval before issuing new shares. Under Companies Act, 2008, the Board alone may issue shares if authorized by the MOI. Issued shares must not exceed authorized shares. 4.7.1 Consideration for issued shares, S40. Before issuing shares, the Board must determine consideration for shares. Terms of issuance. Permitted considerations, S41. Adequate cash or asset-based consideration. Conversion of previously issued securities. Capitalization shares, S47. Shares may be issued for cash. Assets other than cash. Future services or benefits, S44. Once the consideration is received, the company must record the shareholders' details in the securities register. Next page. 4.7.2 Issue of shares for future payments or services. Companies Act, 1973, based on capital maintenance principle. Section 92, only fully paid shares could be issued or allotted. Payment, cash/kind, had to be received before issuance. Itkin v. Hicker Trading Limited, agreement to issue shares before receiving assets was void. Companies Act, 2008, S45, allows shares to be issued for future payments, benefits, or services held in trust until obligations are fulfilled. Voting/appraisal rights not exercisable unless trustee allows. Accounting implications. Consideration for shares must have a determinable monetary value. Failure to record value may result in donations tax, except for public companies. If issued for labor, recipient may need to include value in taxable income. 4.7.3 Issue of capitalization shares. Section 47, Directors may issue capitalization shares on a pro rata basis to shareholders, issued in lieu of dividends. No solvency and liquidity test required, as it is not a distribution, only a reclassification of equity. Optional cash payment instead of shares. Allowed if permitted by the MWA. If cash is chosen, it is considered a distribution and must comply with S46. Shares of one class can be issued as capitalization shares for another class. 4.7.4 When shareholder approval is required to issue shares. 4.7.4.1 Issue of shares to directors and related parties. Section 41 requires special resolution if issued to directors/future directors, prescribed officers/future prescribed officers, related/interrelated persons or their nominees. Exceptions: no approval required if underwriting agreement, preemptive right exercised, S39, proportional issuance on same terms to all shareholders, employee share scheme, S97, public offer, S95(1)H, S96. 4.7.4.2 Issue of shares increasing voting power by 30% or more. Section 41(3) requires special resolution if share issue results in voting power greater than or equal to 30% of that class. Applies to a single transaction or series of integrated transactions. 4.7.5 Preemptive rights. MWA provision. Shareholders have a right to be offered new shares before non-shareholders, in proportion to their voting power. Public and state-owned companies, no automatic preemptive rights. Private companies, default position is preemptive right applies unless MWA states otherwise. Exemptions, no preemptive rights if issued under options or conversion rights for future services or benefits. As capitalization shares, unsubscribed shares can be offered to others if permitted by MWA. 4.7.6 Financial assistance for issuing shares. Section 44, Board can authorize financial assistance for securities issuance if exemptions, not needed if company is a money lender. Requirements. Employee share scheme, S97. Special resolution, within 2 years, for specific or general category recipients. Solvency and liquidity test met. Fair and reasonable terms for the company. MWA conditions satisfied. 4.7.7 Certificated and uncertificated securities. Types of securities. Certificated, evidenced by a certificate. Uncertificated, electronic format, transferable without a written instrument. JSE requirement, only uncertificated securities can be traded. Section 49(3)(a), rights of security holders remain the same regardless of format. Record keeping. Uncertificated securities must be recorded in a central securities depository, CSD. Current CSD licensee, Straight Limited. Trading must be done via CSD participants, banks or Computershare. Conversion rights, S54. Holders can convert uncertificated shares to certificated form by notifying CSD. Case study, Flecky, Proprietary, Limited v. FNB Securities, Proprietary, Limited. Issue, shareholder requested to materialize shares under S54, participant refused, citing FICA obligations. Court ruling. S54 is clear, if a shareholder requests a certificate, the CSD must comply. No discretion for participant, CSD, or company. FICA does not override Companies Act in this context. Supports active shareholder participation. Dematerialization is voluntary, holding a share certificate is optional. Next page. 4.7.8 Records of issued shares. Section 24 of the Companies Act, 2008. Requires companies to maintain specific records, including accounting records accessible from the registered office. Companies must notify the Commission of the location or change in location of records not kept at the registered office. Section 24(4). Profit companies must maintain a securities register or equivalent as per S50. Non-profit companies with members must maintain a members register. Registers reflect names of current shareholders and other security holders. Nominee holdings. Registered holders may not be beneficial owners. Public company nominees must disclose beneficial ownership details. Uncertificated securities must be recorded in the securities register. Securities register serves as proof of recorded facts unless contrary evidence exists. Section 26. Shareholders and non-shareholders have the right to inspect the securities register. Case study, access to securities registers. Basan and another Beyond Point Engineers, Proprietary, Limited. Journalists sought access to securities registers to investigate state tender beneficiaries. Court ruled that S-26(6) must be interpreted to promote Bill of Rights, S-39(2) of the Constitution. Cited law Lucia Sands Share Block Limited v. Barcon. Courts should avoid limiting access to information. Failure to comply with legitimate register access requests is a criminal offense. Held, respondents must provide copies of or allow access to securities registers. Section 37(9). Acquisition and loss of share rights. A person acquires rights when their name is entered in the certificated securities register. As per Central Securities Depository rules for uncertificated securities, a person loses rights when transfer, reacquisition, or surrender is recorded in the certificated securities register. As per Central Securities Depository rules for uncertificated securities. _ 4.8 Unissued shares. Unissued shares, authorized but not yet issued. Default rule, unless altered in law. Directors can reclassify, increase, or decrease unissued shares. _ 4.9 Distributions. Definition: any transfer of cash or assets by a company to shareholders within its group, including dividends, payments in lieu of capitalization shares, share buybacks, own or group company shares, debt obligations incurred for shareholders' benefit, forgiveness of debt owed by shareholders, exclusion, liquidation distributions. Section 37(5)(b). MWA can allow redeemable shares of any class. Redemptions equals distributions, requiring compliance with S-46. Redemption versus buyback. Buyback, company is not obliged to repurchase. Redemption, company must repurchase under share terms. _ 4.9.1 Requirements for distributions. Section 46. Board authorization required unless already legally obligated or court-ordered. Solvency and liquidity test must be passed before distribution. Board resolution must confirm test application and conclusion. Debt or obligation distributions. Solvency test applies when debt is incurred, not when repaid. Court-ordered distributions. If company fails solvency test, it can request court modification. Court must ensure just and equitable resolution while prioritizing financial obligations. _ 4.9.2 Share buybacks. Section 48. Buyback equals distribution under S1 definition. Board decision required, with solvency and liquidity test compliance. Not a buyback if shares acquired by a dissenting shareholder appraisal rights. Prohibitions. A company or its subsidiary cannot buy back shares if it would leave only subsidiary held shares. Convertible/redeemable shares. Approval requirements. From a director, prescribed officer, or related party requires special resolution. Exceeding 5% of a class of issued shares must comply with S-114 and S-115, schemes of arrangement. _ 4.9.3 Cash in lieu of capitalization shares. Board can offer cash instead of shares only if solvency and liquidity test is passed, assuming all shareholders take cash. Cash payments equals distributions, as company assets are reduced. Section 47. Allows capitalization shares of one class to be issued in respect of another class. Next page. 4.10 Debt Instruments. Companies Act, 1973 vs. Companies Act, 2008. 1973 Act, extensively regulated debentures. 2008 Act, uses debt instrument, allowing flexible contractual arrangements. Definition and scope. Securities, as per the Act, equals shares plus debt instruments, including debentures. Debt instrument includes all securities except company shares. Excludes promissory notes and loans. Companies must include debt instruments in their securities register. Issuance and regulation. Section 43. Board authority can issue secured or unsecured debt instruments without shareholder approval, unless restricted by the MWA. Debt instruments may grant special privileges, including attending and voting at general meetings, appointment of directors, allotment of securities, redemption, or substitution for company shares, if MWA allows. A debt instrument may carry shareholder-like rights, such as voting rights. Regulation of debentures. Companies Act, 2008 does not explicitly regulate debentures. Common law and other statutes, for example, Deeds Registries Act, still govern debenture rights and security mechanisms, for example, security over property. Next page. Chapter 5, Shareholders and Company Meetings. _ 5.1 Introduction and Definitions. Shareholders play a crucial role in company decision-making, particularly in corporate governance and financial matters. 5.1.1 Can shareholders act in respect of company matters? Shareholders can act on company matters primarily through meetings and resolutions. Their powers are generally limited to voting on key issues, as management authority rests with the board of directors unless otherwise stated in the MOA or shareholder agreements. 5.1.2 Definitions, words and concepts used in this chapter. Shareholder, a person whose name appears in the company's securities register as the holder of shares. Meeting, a formal gathering of shareholders to discuss and decide on company matters. Quorum, the minimum number of shareholders required for a meeting to proceed. Proxy, a person appointed to attend and vote on behalf of a shareholder. Resolution, a formal decision taken at a meeting, ordinary or special. 5.1.3 Shareholders, the authorization and issuing of shares. Board authority, the board of directors generally has the power to issue shares unless limited by the MOA. Shareholder approval may be required in specific cases, such as issuing shares that impact control or change shareholder rights. 5.2 General comments regarding meetings. Shareholders' meetings are essential for corporate governance and are used to approve financial reports, appoint directors, and make significant company decisions. 5.3 Record date. The record date determines which shareholders are entitled to receive dividends, vote at meetings, receive notices of meetings. 5.3.1 Record date may be set by the board of directors. The board has the power to determine a record date, but it must comply with the Companies Act and the MOA. 5.3.2 Where no record date is set by the board of directors. If the board does not set a record date, the default provisions of the Companies Act apply. 5.4 Calling of shareholders' meetings. Who may call a meeting? The board of directors. A shareholder with the necessary percentage of voting rights, as per the Companies Act or MOA. A court order in certain cases. 5.5 Notice of meetings. Must comply with statutory requirements, including minimum notice period, method of delivery, for example, email, registered mail, details of date, time, venue, agenda, and proposed resolutions. 5.6 Postponement and adjournment of meetings. A meeting may be postponed or adjourned due to lack of quorum, technical issues, for example, inability to connect remotely, unforeseen circumstances. 5.7 Representation by proxy. Shareholders may appoint a proxy to attend and vote on their behalf. The appointment must be in writing and comply with legal requirements. 5.8 Quorum. A quorum is the minimum number of shareholders, or votes, required for a meeting to proceed. If a quorum is not met, the meeting may be postponed or adjourned. 5.9 Conduct of meetings. Meetings must follow formal procedures, including election of a chairperson, adhering to the agenda, recording minutes of the meeting. 5.10 Majority rule and minority protection. Majority rule, shareholder decisions are based on majority votes. Minority protection, the Companies Act provides safeguards against unfair treatment of minority shareholders. 5.11 Some exceptions to applicable rules and formalities. Certain decisions may not require a formal meeting, for example, written resolutions signed by required majority. The MOA may provide alternative rules. 5.12 Shareholders acting other than at a meeting. Shareholders may pass written resolutions instead of holding meetings if permitted by the MOA. Such resolutions require sufficient votes to pass. 5.13 Annual General Meeting, AGM. Public companies and certain others must hold an AGM. Key agenda items include approval of financial statements, election/re-election of directors, approval of dividends, if applicable. 5.14 Convening meetings in special circumstances. Special circumstances may require a meeting to be called by a court order when requested by a sufficient percentage of shareholders. 5.15 Decisions of shareholders and others. 5.15.1 Ordinary resolutions require a simple majority, more than 50%, of votes cast. Used for routine matters, such as appointing directors and approving financial statements. 5.15.2 Special resolutions require at least 75% approval of votes cast. Used for major decisions, such as Amending the MOA, approving mergers or acquisitions, changing the company's name. 5.15.3 Voting rights of shareholders and others. Voting rights are determined by number of shares held, class of shares. Some shares may have different voting rights. Certain non-shareholders, for example, holders of debt instruments, may have voting rights if granted by the MOA. 5.15.4 Proposal of resolutions. 5.15.4.1 Proposal of resolution by Board of Directors. The Board may propose resolutions for shareholder approval. 5.15.4.2 Proposal of resolution by shareholders. Shareholders may propose resolutions if they meet the required percentage of voting rights. 5.16 Shareholder agreements. Shareholders may enter into agreements to regulate their relationship in company affairs. These agreements cannot override the Companies Act or MOA, but they can provide additional rights and obligations. Next page. Chapter 5, Shareholders and Company Meetings. 5.1 Introduction and Definitions. A company is an artificial legal person and acts through shareholders in a general meeting, directors, managers, and employees. The Companies Act, 2008 and the MOA determine who has the authority to act in specific matters. Some decisions require shareholder approval, while others are at the board's discretion. Relevant sections of the Companies Act, 2008. Section 35, Legal nature of company shares and requirement to have shareholders. Section 36, Authorization for shares. Section 38, Issuing shares. Section 50, Securities register and numbering. Legal personality of a company. A company has a separate legal identity from its shareholders and directors. Shareholders do not own company assets, their rights are limited to receiving dividends, if declared. Voting on company matters, as per the acting MOA. Rights on liquidation of the company. Case law, London and others v. Department of Transport, Roads, and Public Works, Northern Cape. The court confirmed the separate legal personality of a company. If a company suffers a loss, only the company, not individual shareholders, can sue. Shareholders cannot claim compensation for a decrease in share value or lost dividends due to company losses. However, if a personal right of a shareholder is violated, they can sue. Issuing of shares and securities register. Section 36. The MOA must specify the classes and number of shares a company may issue. Section 52. A company must update its securities register after issuing securities. Right to access company records. Section 26 of the Companies Act, 2008, Section 26(1). A shareholder or beneficial interest holder has the right to inspect and copy company records, including the securities register. Section 26(2). Outsiders also have a right to inspect the securities register of a profit company or the members' register of a non-profit company. Case study, Nova Property Group Holdings Limited v. Cobbett. The respondents sought access to securities registers under Section 26(2). The appellants refused access, arguing Section 26(2) grants only a qualified right, subject to BIA. The requester's motive should be considered before granting access. The court disagreed, ruling Section 26(2) provides an unqualified right of access to the securities register. Companies must disclose information under the Companies Act due to the constitutional right to access information, Section 32 of the Constitution. The Companies Act promotes openness and transparency, Section 7. Key legal principles from the judgment. Company information is not purely private. Companies play a public role. Section 26(2) overrides PIA restrictions regarding access to the securities register. Privacy concerns raised by the appellants were dismissed because the right to privacy is minimally affected. Information in a securities register is basic, name, address, and unique identifier. No sensitive financial or political data is disclosed. Next page. 5.1.1 Can shareholders act in respect of company matters? Unalterable provisions. Some provisions in the Companies Act, 2008 cannot be modified by a company's Memorandum of Incorporation, MOI. Example, Section 71(1), shareholders have the right to remove a director via ordinary resolution. Alterable provisions and MOA impact. The MOA can modify certain provisions unless explicitly unalterable by the Act. Key to understanding who can act in a company and requirements for transactions. Shareholder approvals. Certain transactions require shareholder resolutions. Section 41, share issues to specific persons need special resolution. Section 66(9). Director remuneration must be approved by special resolution. Special resolution requirements summarized in 5.1.5.2. Ordinary versus special resolutions. Default percentages can be changed in moi. Ordinary resolution, 50.1%. Special resolution, 75%. Different definitions possible for different transactions. Moi's role in restricting directors' powers. The moi can require shareholder pre-approval for certain board decisions. Section 46, board authorizes distributions, for example, dividends, but moi can require shareholder approval. Section 15(2)(a), 3, moi may impose higher standards or stricter requirements than unalterable provisions. Underscore. 5.1.2 Definitions, words and concepts used in this chapter. Key definitions, Section 1 of the Act. Securities, shares, debentures, or instruments issued by a profit company. Securities register, register maintained per Section 50 for issued securities. Share, a unit of ownership in a profit company. Shareholder, a holder of a share listed in the securities register. Table 5.1, Key terms. Concept definition. Securities proof of ownership, equity, or company debt, debentures. Includes shares and debt instruments. Shares ownership units in a company, granting voting rights, dividends, and liquidation rights. Debentures debt instruments giving holders interest payments and repayment rights. Financial instrument a contractual right creating an asset for one party and liability or equity for another, for example, shares or debentures. Authorized versus issued capital authorized, max shares a company may issue per mois. Issued, shares actually allocated to shareholders. Shareholder holder of issued shares recorded in a certificated, physical, or uncertificated, electronic, register. Underscore. Structure of Part F of Chapter 2 of the Companies Act, 2008. Shareholder governance provisions. Section 58, right to representation by proxy. Section 59, record date for determining shareholder rights. Section 60, shareholders can act without a meeting. Sections 61 to 64, rules for shareholder meetings, notices, conduct, quorum. Section 65, requirements for shareholder resolutions. Shareholder meetings. The Act defines securities broadly, so holders of debt instruments with voting rights may be included in shareholder meetings. Shareholder duties. No general legal duty towards the company. May have contractual obligations under a shareholders' agreement. Primary duty, compliance with the moi. Underscore. Case study, shareholder relationships, Hullett v. Hullett. Facts. 3 individuals formed a small business with equal shares, loans, and directorships. Pre-existing personal trust was a factor in the company's internal relationships. Court ruling. A company is more than just a legal entity, its members have expectations and obligations beyond formal structure. Ebrahimi v. Westbourne Galleries Limited referenced. The shareholders' relationship was akin to a quasi-partnership. A shareholder cannot overreach fellow shareholders, particularly in closely held companies. Next page. 5.1.3 Shareholders, the authorization and issuing of shares. Authorization of shares, Section 36(3), Companies Act 2008, the Board of Directors may, unless restricted by the moi, increase or decrease the number of authorized shares. Reclassify any authorized but unissued classified shares. Classify authorized but unissued unclassified shares. Determine preferences, rights, limitations, or terms of shares in a class. Alterable provision. If not restricted by the moi, directors can authorize shares without shareholder approval. Section 38 allows directors to issue shares in some cases without shareholder approval. Issuing of shares. Companies Act 1973, Section 221, required shareholder approval for additional share issues. Companies Act 2008, Section 38. Board may resolve to issue shares without shareholder approval, within the limits of the moi. Section 41(3). Directors can issue shares without shareholder approval only up to 30% of the voting power of that class. Case study, Reason Limited v. Accelerate Holdings Limited and others. Section 41(3) protects shareholders from excessive dilution. Purpose, prevent directors from issuing excessive shares without shareholder approval. Violation consequences, a transaction exceeding the 30% limit should be declared void. When shareholder approval is required, Section 41(1). Special resolution required for issuing shares, securities, options, or rights to a director, future director, prescribed officer, or future prescribed officer. A person related to the company, director, or prescribed officer. A nominee of such a person. Exceptions under Section 41(2), no shareholder approval required if issue is under an underwriting agreement. In exercise of a preemptive right, Section 39, proportionate to existing holdings and on the same terms for all shareholders. Part of an employee share scheme, Section 97. Part of a public offer, Section 95(1)(h), read with Section 96. Consequences of issuing shares in contravention of Section 41. 1. The issue is void. 2. Director liability under Sections 41(5), 77(3), and 218(2). Liable for losses, damages, or costs incurred by the company. Any contravening person is liable for any loss suffered by another person. Case study: contraventions of Sections 41(1) and 41(3). Reason case: court held that damages alone are insufficient to protect shareholders. Share issues violating Section 41(3) must be declared void. Precedent: prevents directors from circumventing the 30% limitation. Summary: Board's power to authorize and issue shares. Case: CDH Invest NVB Petrotank South Africa, Proprietary, Limited and another. Directors can issue shares, but only within authorized limits. Directors can increase authorized shares, Section 36(3). Must comply with Section 76(3), proper purpose, best interests, due care, skill, diligence. Restrictions on directors' power to issue shares. 1. Section 76(3) plus common law principles, directors' duties. 2. Number of authorized shares, which directors may increase, subject to limitations. 3. Section 41(1) and 41(3) restrictions, shareholder approval required in certain cases. Underscore. 5.2 General comments regarding shareholders' meetings. Key principles. Must be properly called and convened. Notice must be given to all entitled persons. Must be held at an accessible time, date, and place. Quorum requirement must be met before commencement. Underscore. 5.3 Record date. Definition: Section 1, Companies Act 2008, Record date. The date a company determines shareholder identity and shareholdings for legal purposes. Determines rights such as receiving meeting notice, voting at a meeting. 5.3.1 Record date set by Board. The Board may set a record date for receiving notice of a shareholders' meeting, participating and voting in a meeting, deciding matters via written consent or electronic communication. Restrictions: cannot be earlier than the date of determination, cannot be more than 10 business days before the event, must be published to shareholders. 5.3.2 Where no record date is set. If the Board does not set a record date, the default record date is for a meeting, the latest date by which the company must give notice. For any other action/event, the date of the action/event. Underscore. 5.4 Calling of shareholders' meetings. Who may call a meeting? The Board of Directors or any person authorized by the MOA. When must a meeting be called? If required by the Companies Act or MOA, for example, electing directors. If shareholders demand a meeting, at least 10% of voting rights, unless the MOA specifies a lower threshold. Key points on shareholder demands for meetings. Demand must specify the purpose of the meeting. A company or shareholder may apply to court to set aside a demand if it is frivolous or vexatious. A shareholder may withdraw a demand before the meeting starts. If demands are withdrawn, and the remaining requests fall below the required percentage, the meeting must be cancelled. Case study: Butler v. Van Zyl. Facts: majority shareholders, 78%, wanted to remove the MD. They demanded a meeting under Section 61(3). The MD opposed it and sought a court order to block the meeting. Court decision: shareholders were entitled to demand the meeting. A director was authorized to call the meeting in response. Section 61(12). If a company fails to convene a meeting as required, shareholders may apply to court. Case study: court-ordered meetings. CDH Invest NVB Petrotank South Africa, Proprietary, Limited and another. Court examined whether an applicant made a valid case for court intervention under Section 61(12). Court's reasoning: judicial oversight is necessary before ordering a meeting. Courts will not simply rubber stamp technical compliance. The applicant must show the meeting is sought bona fide, for a legitimate purpose, and in the company's best interests. Outcome: the applicant already controlled the board, 3 out of 5 directors. Court questioned why judicial intervention was necessary when the board could call the meeting itself. Next. Page 5.5 Notice of Meetings. A shareholders' meeting notice must be in writing. Include the date, time, and place of the meeting. State the record date, if applicable. Explain the general and specific purposes of the meeting. Be sent 15 business days before, public/non-profit voting companies, or 10 business days before, other companies, unless the MWA prescribes a longer period. Include proposed resolutions and indicate the voting rights percentage required for adoption. For an AGM, include a summary of financial statements in the process to obtain full financials. State that shareholders may appoint a proxy. Indicate that participants must provide proof of identity. Defective or missing notices. A meeting may proceed if all entitled voters are present. Acknowledge receipt of the notice. Waive notice or ratify a defective notice. If a material defect affects only specific agenda items, those items can be removed, and the meeting may proceed with the remaining agenda. Immaterial defects or accidental failures in delivering notices to specific shareholders do not invalidate the meeting. A shareholder present is deemed to have received or waived notice. Case study, Thompson v. Ellipse, Proprietary, Limited. Facts: a shareholder was not given notice of a meeting where key decisions were made. Court findings: the meeting was improperly constituted, even though a quorum was present. Item 7.5 of Schedule 5, Companies Act, 2008, mandates that statutory notice requirements apply from May 1, 2011, overriding the MWA. Section 62(1), 3, and 4 of the Companies Act requires notice to all shareholders, prescribes content, and allows for ratification of defective notices. Underscore 5.6 Postponement and adjournment of meetings. A meeting may be postponed for 1 week if no quorum is present within 1 hour of the scheduled start time. At the postponed meeting, present members, in person/proxy, constitute a quorum. Business items may be postponed to a later time in the same meeting without motion or vote. Chairperson's authority to extend the 1-hour limit. Allowed if exceptional circumstances, for example, weather, transportation, electronic issues, affect attendance. Allowed if delayed shareholders have communicated an intent to attend and their presence would constitute a quorum. Alterable provisions. The 1-hour rule and 1-week postponement can be modified in the MWA. Notice of postponement is required only if the venue changes. Adjournment of meetings. If a quorum is present, the meeting may continue even if attendance reduces, provided at least one voting shareholder remains. A meeting may be adjourned if supported by a majority of voting rights present. Adjournment can be to a fixed date/place or until further notice. Notice is required only if adjourned until further notice. A meeting cannot be adjourned beyond 120 business days after the record date, or 60 business days after the adjournment, unless MWA allows changes. Next. RITI shareholders. Chapter 14 of this book discusses these provisions and principles. Some of the safeguards and remedies as discussed in Chapter 14 include the following. There are remedies against directors who have abused their position, and directors have fiduciary duties both in terms of the Companies Act, 2008 and in terms of the common law. There is relief from oppressive or prejudicial conduct in terms of S-163. There are descending shareholders' appraisal rights in terms of S-164. There is a derivative action in terms of S-165. There is an additional remedy to protect rights of securities holders in terms of S-161. In addition to the above, depending on the percentage of shares held, a minority could demand a meeting of shareholders in terms of S-61, as discussed in paragraph 5.4 above, and a minority can block a special resolution that is required before certain transactions can take place. Page 5.7 Representation by Proxy. Common Law vs. Companies Act, 2008. At common law, shareholders had no right to appoint a proxy. Section 58(1) of the Companies Act, 2008 allows shareholders to appoint any individual as a proxy. Proxies do not need to be shareholders. A company's MWA may allow appointment of multiple proxies. Rights and duties of a proxy. Can attend, participate, speak, and vote at meetings. Inger v. Maxwell, a valid meeting requires at least 2 persons present. A sole person holding all proxies does not constitute a valid meeting. Appointment of a proxy must be in writing and signed by the shareholder. Valid for 1 year. Unless specified otherwise. Multiple proxies can be appointed for different shares. Proxies may delegate authority. Proxy forms must be submitted to the company before the proxy exercises rights. MWA and proxy appointment. Berry v. Clearwater Estates NPC. MWA required proxies to be lodged 48 hours before a meeting. Court ruled this provision invalid under S15(1) as it conflicted with S58(1), which states proxies may be appointed at any time. Section 58(1) is unalterable by MWA, but S58(3) can be altered. Venturno v. Silver Lakes HOA NPC. Rule limiting proxies to 5 members was void as it conflicted with S58(1), which allows unrestricted proxy appointments. Revocation of proxy. Proxy appointment is not irrevocable. Automatically suspended if shareholder acts directly. Can be revoked in writing or by appointing a new proxy. Voting rights of a proxy. Can vote as they think fit unless instructed otherwise. Shareholder may indicate voting preferences on the form. Company's role in proxy appointment. May suggest proxies but cannot compel shareholders to choose from a list. Form must allow for shareholders' own choice and voting instructions. Validity of proxy forms. Gitz v. Sparwater Gold Mining Company Limited, minor non-compliance, for example, missing date, did not invalidate proxy. Davy v. Anyaminga Petroleum Limited. Failure to specify number of shares was a material defect, rendering proxy invalid. 5.8 Quorum. Definition. Minimum number of shareholders required for a valid meeting. Default quorum requirements, Companies Act, 2008. At least 25% of voting rights must be represented. MWA may specify a different percentage. If the company has more than 2 shareholders, at least 3 shareholders must be present. Resolutions and quorum. Ordinary resolution, greater than 50% of voting rights, can be passed even if only a quorum, 25%, is present. MWA may require a higher quorum for certain transactions. 5.9 Conduct of meetings. Voting methods. Show of hands. 1 vote per person, regardless of shares held. Poll. Voting rights proportional to shares held. Electronic meetings. Meetings may be held entirely online or allow remote participation. Electronic communication must enable real-time interaction. Notice of meeting must inform shareholders about remote participation options. Shareholders bear the cost of electronic access. Abstention from voting. Abstaining from voting equals vote against the resolution. Company records. Section 24(3)(d). 2. Company must keep documents related to shareholder resolutions. Section 24(3)(e). Written communications to shareholders must be kept for 7 years. 5.10 Majority Rule and Minority Protection. Majority Rule. Minority shareholders are bound by the decisions of the majority. Garden Province Investment VLF, Proprietary, Limited. Sale of company asset opposed by minority shareholders. Court ruled sale was not unfairly prejudicial as it was at market value. Majority decisions are valid unless there is a lack of probity, unfair discrimination, or violation of fair play. Majority supremacy. Summel v. President Brand Gold Mining Company Limited. Shareholders are bound by lawful majority decisions, even if personally disadvantageous. Protection for minority shareholders. Companies Act, 2008 and Common Law Remedies. Section 163, Relief from oppressive or prejudicial conduct. Section 164, Dissenting shareholders' appraisal rights. Section 165, Derivative action, action on behalf of the company. Section 161, Additional remedy for securities holders. Minority shareholders may demand a meeting under S61. Block a special resolution if required for certain transactions. A company's MWA may also include minority protection measures. Next page. 5.11 Some exceptions to applicable rules and formalities. A shareholder of a profit company, excluding state-owned companies, with only 1 shareholder may exercise all voting rights. Rules on record dates, proxies, and meeting notices do not apply to a single shareholder profit company. A single director of a profit company, excluding state-owned enterprises, may exercise all board powers/functions without notice or formalities, unless restricted by the MWA. If all shareholders of a company, excluding state-owned enterprises, are also directors, any matter requiring shareholder decision can be decided without notice or formalities, unless restricted by the MWA. All directors must be present at the board meeting when the matter was referred to shareholders. A quorum must be present, and the resolution must meet the required voting threshold. A company's board may authorize a representative to attend and vote at shareholders' meetings of another company in which it holds securities. 5.12 Shareholders acting other than at a meeting. The Companies Act, 2008 allows for resolutions without convening a meeting. For an ordinary resolution, The company must send the proposed resolution to all entitled voters. Shareholders have 20 days to submit a written vote. The resolution is adopted if it meets the required voting threshold, equivalent to a shareholders' meeting. Election of a director may also occur through written polling of all eligible shareholders. Within 10 business days of adoption, the company must inform all entitled shareholders of the voting results. Business requiring an annual general meeting, AGM, cannot be conducted without convening a meeting. 5.13 Annual General Meeting, AGM, first AGM, must be held within 18 months of incorporation. Subsequent AGMs must be held within 15 months of the previous AGM, extension possible via company's tribunal. AGM agenda must include Directors' Report, audited financial statements, and Audit Committee Report. Election of directors. Appointment of auditor for the next financial year and appointment of the Audit Committee. Any matters raised by shareholders, with or without prior notice. 5.14 Convening meetings in special circumstances. If no directors or all directors are incapacitated, a person authorized by the MWA may convene the meeting. If no one is authorized, a shareholder may request the company's tribunal to order a meeting. If a company fails to convene a meeting, a shareholder may apply to court to compel the meeting. The company must compensate the shareholder for legal costs incurred in seeking a tribunal or court order. Failure to hold a required meeting does not invalidate company existence or actions. 5.15 Decisions of shareholders and others. Two types of shareholder resolutions under the Companies Act, 2008. Ordinary resolution. Special resolution. Resolutions may be passed at a shareholders' meeting by written consent under S60. Holders of debt instruments may have voting rights at shareholders' meetings in certain companies. Next page. 5.11 Exceptions to applicable rules and formalities. A single shareholder of a profit company, excluding state-owned enterprises, may exercise all voting rights. Rules on record dates, proxies, and meeting notices do not apply to a profit company with only one member. A single director of a profit company, excluding state-owned enterprises, may exercise board powers without formalities unless the MWA states otherwise. If all shareholders are also directors, excluding state-owned enterprises, they may decide matters referred to them by the board without formalities, provided they were personally present at the board meeting when the matter was referred. A quorum was present. Resolutions are adopted with necessary shareholder support. A company's board may authorize a representative to act on its behalf at another company's shareholders meeting. 5.12 Shareholders acting other than at a meeting. Companies can pass resolutions without meetings by submitting the proposed resolution to all entitled voters. Shareholders must return written votes within 20 days. A resolution is adopted if supported by the necessary voting rights, as if at a meeting. Director elections can also be conducted via written polling. The company must deliver voting results to shareholders within 10 business days. Annual General Meeting, AGM, business cannot be conducted without a formal meeting. 5.13 Annual General Meeting, AGM, first AGM, within 18 months of incorporation. Subsequent AGMs, no more than 15 months apart, extension possible with company's tribunal approval. Mandatory agenda items. Directors' Report, audited financial statements, Audit Committee Report, election of directors, appointment of an auditor and audit committee, matters raised by shareholders. 5.14 Convening meetings in special circumstances. If a company has no directors or they are incapacitated, a person authorized by the MWA may convene a meeting. If no authorized person exists, a shareholder may request the company's tribunal to issue an order to convene a meeting. A shareholder may also apply to court to compel a meeting. The company must compensate shareholders for legal costs incurred. Failure to hold a required meeting does not affect the company's existence or its actions. 5.15 Decisions of shareholders and others. Shareholders pass decisions via ordinary or special resolutions at meetings or under S60, acting outside a meeting. Holders of debt instruments may be allowed to vote at shareholders' meetings in certain cases. 5.15.1 Ordinary resolutions. Passed with greater than 50% voting rights unless a higher threshold is set in the MWA. MWA can set a higher threshold for specific decisions, but a 10% margin must exist between the threshold for ordinary and special resolutions. The minimum threshold for ordinary resolutions is 50%. Exception: a director's removal cannot require more than 50% support under S65(8). 5.15.2 Special resolutions. Requires greater than or equal to 75% voting rights, or a different percentage set in the MWA. A 10% margin must exist between ordinary and special resolution thresholds. Special resolutions are required for MWA amendments, except where directors alter authorized shares, S16, S36(3), 4. MWA consolidation ratification, S18(1)(b), S17(5). Ratification of actions exceeding MWA limits, S22. Issuing shares to directors or related parties, S41(1), S41(3). Financial assistance for securities issuance or to directors/related entities, S44, S45. Share buybacks, if involving directors or exceeding 5% of a class of shares, S48(8). Directors' remuneration approval, S66(9). Voluntary winding up of a solvent company, S81. Court-ordered winding up, S81(1). Deregistration for foreign transfer, S82(5). Fundamental transactions, S112 to 116. Revoking special resolutions affecting dissenting shareholders' appraisal rights, S164(9)(c). Other matters specified in the MWA, S65(12). 5.15.3 Voting rights of shareholders and others. Definitions. Voting power, percentage of voting rights exercisable on a matter. Voting rights, shareholder rights to vote on a matter. Voting rights depend on the MWA, not statutory rules. Flexible voting structures are allowed. Shareholders may have no voting rights or greater votes per share for specific transactions. Debt instrument holders, excluding promissory notes and loans, may have voting rights under S43, as defined in the MWA. 5.15.4 Proposal of resolutions. Resolutions can be proposed by Board of Directors. Shareholders, minimum of 2 required. Resolutions must be clear, specific, and accompanied by explanatory material. If a resolution lacks clarity or information, a shareholder or director may apply to court to prevent a vote until corrected. Once adopted, a resolution cannot be challenged for lack of clarity or information. 5.15.4.1 Proposal by Board of Directors. The board may propose resolutions for voting at a meeting, by vote, or by written consent. 5.15.4.2 Proposal by shareholders. Any 2 shareholders may propose a resolution for voting at a meeting or by written vote. 5.16 Shareholder agreements. Shareholders can enter into agreements to govern their rights and obligations beyond the MWA. Common provisions include shareholder rights to appoint directors, decisions requiring shareholder consent, limits on incurring debt or selling assets, control over strategic business decisions. Giwala v. Guernsey Property Limited. A shareholders' agreement requiring a shareholder to be appointed as a director was held valid. S15(7). Shareholder agreements must comply with the company's acting MWA. Inconsistent provisions are void. Next page. Chapter 6. Directors of a company. Underscore. 6.1 Directors of a company. An introduction. Directors manage and control the affairs of a company. The Companies Act, 2008 outlines directors' powers, duties, and liabilities. Directors must act in the best interests of the company. 6.2 Meaning of director, types of directors, and board composition. Definition of director includes members of the board, alternate directors, and prescribed officers. Types of directors. Executive directors, involved in daily management. Non-executive directors, not involved in daily management but provide oversight. Independent directors, free from material relationships with the company. Alternate directors, stand in for an absent director. Board composition. A company's Memorandum of Incorporation, MOI, may specify the number and type of directors. 6.3 Directors and managers. Directors set strategy and oversee management. Managers handle daily operational decisions under the board's guidance. 6.4 Duties and liabilities of directors. 6.4.1 Fiduciary duty and duty of care, skill, and diligence. S76(3). Act in good faith, in the best interests of the company, and avoid conflicts of interest. Apply the reasonable care, skill, and diligence expected of a director. 6.4.2 The business judgment test. S76(4). Directors are protected if a. Act in good faith and for a proper purpose. Make an informed decision based on reasonable diligence. Do not have a personal financial interest in the decision. 6.4.3 Standards of directors' conduct. S76(2). Avoid deriving personal benefits from company information. Prevent harm to the company through negligent or improper conduct. 6.4.4 Directors' personal financial interests. S75. Directors must disclose any personal financial interest in company transactions. 6.4.4.1 Companies where there is more than one director. Director with a conflict must disclose the interest before the decision is made. Recuse themselves from discussions and voting. 6.4.4.2 Companies where there is a single director. The director must disclose the conflict in writing. 6.4.5 Liability of directors. SS 77 and 218 to 6.4.5.1 Section 77, Liability of Directors and Prescribed Officers. Directors are personally liable for breach of fiduciary duties, acting without authority, fraudulent or reckless trading. 6.4.5.2 Section 218(2), Civil Actions. Any person harmed by a director's misconduct can claim damages. 6.4.6 Indemnification and Directors' Insurance. A company may indemnify directors except for willful misconduct or fraud. Directors' liability insurance covers legal costs and liabilities. 6.5 Number of directors and consent. Private companies, at least one director. Public and state-owned companies, at least 3 directors. Directors must consent in writing before appointment. 6.6 Memorandum of Incorporation may vary certain provisions of the Companies Act, 2008. The MOA can modify the director-related provisions, except where expressly prohibited. 6.7 Ineligible and disqualified persons. Persons disqualified from being directors include declared delinquent directors, insolvent persons, convicted individuals for fraud, dishonesty, or other serious crimes. 6.8 Exemptions to director disqualifications. Court may grant exemptions under certain conditions. 6.9 Application to declare a person delinquent or under probation. Interested parties, for example, shareholders, regulatory bodies, may apply to declare a director delinquent. 6.10 Suspending and setting aside orders of delinquency. Delinquency status may be suspended or removed by court application. 6.11 First directors of a company. First directors are appointed in the MOA or by incorporators. 6.12 Vacancies on the board. A director's position becomes vacant due to resignation, removal, disqualification, or death. 6.13 Filling of vacancies. The board or shareholders may appoint a replacement, depending on the MOA. 6.14 Removal of directors. 6.14.1 Removal by shareholders. Ordinary resolution required, S71-1. 6.14.2 Removal by Board of Directors. If allowed by MOA, the board may remove a director, S71-3. 6.14.3 Removal and breach of contract. Removal does not affect contractual claims for unfair dismissal. 6.15 Board committees and the Audit Committee. Board committees may be formed to delegate specific responsibilities. Audit Committee required for public and state-owned companies. 6.16 King 4 Proposals on Board Committees. King 4 Code recommends board committees for risk management, remuneration, and governance. 6.17 Board meetings. 6.17.1 Electronic communications. Board meetings may be held electronically, subject to the MOA. 6.17.2 Notice of board meetings. Directors must receive reasonable notice of meetings. 6.17.3 Quorum at board meetings. A minimum number of directors must be present for valid decisions. 6.17.4 Voting at board meetings. Majority vote generally required unless MOA specifies otherwise. 6.17.5 Minutes and resolutions of board meetings. Minutes must be kept for 7 years, S24-3D. _ This summary captures key provisions of Chapter 6, Directors of a Company, focusing on directors' roles, duties, liabilities, and board governance under the Companies Act, 2008. Let me know if you need further details. Next page. Chapter 6, Directors of a Company. _ 6.1 Directors of a Company, an Introduction. Section 66(1) of the Companies Act, 2008. The Board of Directors manages and directs the company's business and affairs. Powers of directors are subject to restrictions in the Companies Act, 2008. Memorandum of Incorporation, MOI. Certain transactions require shareholder approval. Appointment of directors. Shareholders usually appoint directors, except those appointed by the MOA or ex officio directors. A separate resolution is required for each director's appointment. Case law, R. V. Kritzinger. A company, Being an artificial entity, acts through its directors. The board represents the company when acting in their official capacity. Summary of relevant Companies Act sections. Section heading Key points paragraph reference. 66 Board, Directors, and Prescribed Officers. Board manages and directs the company. 6.1. 68 Election of Directors. Shareholders elect directors. 6.1. 69 Ineligibility and disqualification lists grounds for ineligibility and disqualification. 6.7. 70 Vacancies on the board covers how vacancies arise and are filled. 6.11, 6.12. 71 Removal of directors. Shareholders or the board can remove directors. 6.13. 72 Board committees allows companies to form committees. 6.14. 73 Board meetings. Regulations for board meetings. 6.16. 74 Directors acting outside of meetings. Round robin resolutions permitted. 6.4.1. 75 Directors' personal financial interests. Disclosure and recusal requirements. 6.4. 76 Standards of Directors' conduct. Fiduciary duties, duty of care, skill, and diligence. 6.4. 77 Directors' liability. Personal liability for certain acts and omissions. 6.4. 78 Indemnification and insurance rules for director liability coverage. 6.4. Underscore. 6.2 Meaning of director, types of directors, and board composition. Definition of director, S1, Companies Act, 2008. A director is a member of the board or an alternate director. De facto directors, not officially appointed but act as directors, are included. Types of directors recognized in the Act. Type of director. Characteristics. Ex officio director holds the position due to another office or status, for example, CEO/CFO. Moi appointed director appointed as per moi, not necessarily by shareholders. Alternate director substitutes for an elected or appointed director when needed. Elected director. At least 50% of directors in a profit company must be elected by shareholders. Temporary director appointed to fill a vacancy as per moi provisions. Corporate governance considerations. A majority of independent, non-executive directors is recommended to reduce conflicts of interest. Independence means no relationships or positions that may unduly influence decision-making. Case law, PWAU National Provident Fund v. PWAU. A director must act independently and serve the company's best interests, not those of shareholders who appointed them. Unitary board structure, endorsed by Companies Act, 2008. A single board with both executive and non-executive directors, no two-tier structure. Executive directors, company employees, for example, CEO. Non-executive directors, not company employees. Case law, Howard v. Harrigal. No distinction in duties between executive and non-executive directors. All directors are fiduciaries and must act in utmost good faith. Underscore. This covers sections 6.1 and 6.2 with emphasis on legislation and case law. Let me know if you need further refinements. Next page. 6.3 Directors and Managers. Differences between directors and managers. Directors, not necessarily employees, provide leadership and strategic direction. Managers, employees responsible for implementing strategies set by the directors. King 4 Recommendation. Majority of non-executive directors for objective decision-making. Non-executive directors should ideally be independent. Board to assess and disclose independence in the integrated report. Comparison of directors and managers. Aspect directors managers. Leadership provides strategic leadership at the top. Implement strategies on behalf of directors. Decision-making determine the company's future, protect assets and reputation, consider stakeholders. Implement board decisions and policies. Duties and responsibilities ultimately responsible for long-term prosperity, bound by legal and fiduciary duties. Fewer legal responsibilities but must act in employer's interest. Relationship with shareholders accountable to shareholders, can be removed by them, act as fiduciaries. Appointed and dismissed by directors, no direct interaction with shareholders. Ethics and values determine corporate ethics and values. Follow and enforce board set ethics. Company administration ultimately responsible, though duties may be delegated. Perform delegated administrative duties. Statutory provisions liable for offenses under Companies Act, 2008. Generally not liable under the Act. Disqualification can be disqualified under Companies Act, 2008 or Company Moi. Employment controlled by the board under contract. King IB's Code on Corporate Governance, Functions of the Board. Strategic direction, provide overall direction to the company. Policy and planning approval, approve policies that enable strategic direction. Oversight and monitoring, ensure management executes and implements policies. Accountability, ensure transparency and proper reporting. Compliance obligations. Directors must comply with duties imposed by statutes, particularly the Companies Act, 2008. 6.4 Duties and liabilities of directors. Pre-2008 efficiencies in company law. Companies Act, 1973 lacked clear rules on directors' duties and liabilities, leaving them mainly to common law. Key issues identified in law reform. No comprehensive statutory framework for directors' duties and accountability. Weak enforcement mechanisms led to directors avoiding legal consequences. Need for statutory accountability to shareholders. Companies Act, 2008, key reforms. Partial codification of directors' duties, making them more explicit. Introduction of personal liability for directors in certain circumstances. Common law principles still apply unless modified by the Act. Business judgment test introduced as a statutory defense for directors. Key sections on directors' duties in the Companies Act, 2008. Section provision. S-76 Standards of Directors' Conduct, duty to act with care, skill, and diligence, avoid personal benefit. S-75 Avoidance of conflicts of interest, disclosure of personal financial interests in transactions. S-77 Circumstances where directors are personally liable for company losses due to their actions. Definition of director for Sections 75 and 76. Includes directors, alternate directors, prescribed officers, members of board committees, even if not board members, audit committee members, who must be board members. Director liability under the Companies Act, 2008. S-76 Violation, a director failing to act with care, skill, and diligence can be held liable. S-218 Liability. Any person violating the Act is liable for losses suffered by another due to the contravention. Contrast with the Companies Act, 1973, where liability generally required recklessness or fraud. Next. Page 6.4.1 Fiduciary duty and duty of care, skill, and diligence. S-76 Statutory duty of directors, Companies Act, 2008. S-76 Directors must exercise their powers and perform functions. A. In good faith and for a proper purpose. B. In the best interests of the company. C. With the care, skill, and diligence reasonably expected of. I. A person performing similar functions. 2. A director with their general knowledge, skill, and experience. Fiduciary duties apply only to directors, not shareholders. Case law on fiduciary duties. Bhagwandis v. Dr. Ghulam Omar Incorporated, Bhagwandis v. GMO Imaging, Proprietary, Limited. Held, shareholders do not owe fiduciary duties to the company. Context, doctors, shareholders, not directors, left a dysfunctional medical practice, which was reasonable. Visor Citrus, Proprietary, Limited v. Goat Citrus, Proprietary, Limited and others. Test for fiduciary duty. Objective test, what a reasonable director would do. Subjective test, the director's personal skills and experience. Held, directors must subjectively believe their decision is in the company's best interests with a rational basis. Cyberscene Limited v. iKiosk Internet and Information, Proprietary, Limited. Held, breach of fiduciary duty where directors sabotaged contractual opportunities for personal gain, used confidential information to benefit a rival, improperly competed with the company. Robinson v. Randfontaine Estates Gold Mining Company Limited. Held, directors cannot make a secret profit at the company's expense. Place personal interests in conflict with fiduciary duties. A director purchased property personally when they should have done so for the company and resold it at a profit. The company was entitled to the profit. Gursey v. Tiber Developments, Proprietary, Limited. Held, a director of a property development company is not automatically required to offer all property opportunities to the company unless explicitly agreed. Lewis Group Limited v. Woolham. Debate, whether directors owe fiduciary duties only to the company or also to shareholders. No clear support in the Act for a separate duty to shareholders. Visor Citrus. Held, fiduciaries must disclose actions, not reasons for their actions. Court considered the interrelationship between S-163, relief from oppressive conduct, and directors' fiduciary duties. Employees and fiduciary duties. Phillips v. Fieldstone Africa, Proprietary, Limited. Held, employees must account for secret profits if gained through employment opportunities. Principle, even non-directors in fiduciary positions cannot make undisclosed profits. Daewoo Heavy Industries, S.A., Proprietary, Limited v. Banks. Held, most employment and agency contracts imply a fiduciary duty. Dorbel Limited v. Forster. Held, executive director breached fiduciary duty by taking secret profits, R36 million, without informing the company. Principle, if an opportunity arises while in a fiduciary role, it belongs to the company. Conflict of interest and unauthorized profits. Architects CCV Mpalawa. Court referred to Ultraframe, UK, Limited v. Fielding. 2 fiduciary strands. No conflict rule, directors cannot have conflicting interests. No profit rule, directors must account for profits gained due to their position unless consent is given. Principle, a fiduciary can retain a benefit only if the principal gives informed consent. Good faith and proper purpose, S76-3, CDH Invest NVV Petrotank South Africa, Proprietary, Limited and others. Issue, directors increased authorized shares via round-robin resolution without explanation. Held, lack of justification violated the good faith standard under S76-3. The resolution was invalid as it was not exercised for a proper purpose. Fiduciary duties in a group of companies. Each company in a group is a separate entity. Directors of a subsidiary must prioritize the subsidiary's interests over the group's interests. S76-2. Directors must not cause harm to the company or its subsidiary. The Act expands fiduciary duties to include subsidiaries, unlike common law. _ This summary highlights key principles and case law on fiduciary duties, the duty of care, and conflicts of interest under South African corporate law. Next page. 6.4.2 The Business Judgment Test, S76-4, Section 76-4 of the Companies Act, 2008 introduces the business judgment test in South African law, relating to a director's duty of care, skill, diligence, and acting in the company's best interests. A director is protected from allegations of breach of duty if A. took reasonably diligent steps to become informed about a matter, had no material personal financial interest in the decision or disclosed the conflict per S75, had a rational basis for believing the decision was in the company's best interests. Business judgment rule. A director acting in good faith and making an incorrect decision cannot be held liable if the decision was rational and informed. Purpose, encourages directors to take calculated risks without fear of personal liability, preventing the stifling of innovation. Safe harbor, protects directors whose decisions, though ultimately unsound, were made informed, in good faith, with care, in the company's best interests. Reliance on others, S76-4b, a director may rely on competent employees, professional advisors, for example, legal counsel, accountants, board committees or non-member directors, unless there is reason to distrust them. Arguments for the rule. Encourages competent persons to become directors. Allows risk-taking in business. Arguments against the rule. May lower the standard of director conduct. Difficult to define and codify, as seen in U.S. company law. Case study, Fisheries Development Corporation of S.A. Limited v. Jorgensen. Directors' duty of skill and care depends on the nature of the company's business. Directors are not required to have special business acumen. Directors may assume that officials will perform duties honestly. _ 6.4.3 Duty to avoid personal benefits and harm to the company, S76-2, Prohibitions on directors. Must not use their position or obtain information for personal benefit. Must not cause harm to the company or its subsidiaries. The duty extends beyond common law to subsidiary companies under the Companies Act, 2008. Disclosure of information. Directors must inform the board of any relevant information unless it is immaterial to the company. It is publicly available. It is already known to other directors. Directors are exempt from disclosure if bound by confidentiality obligations. Case study. Kukama Bilo Bilo. S76-2b imposes a duty to inform the board as soon as possible. Director failed to disclose a fraudulent transaction, violating duty to disclose. Court held that strained relationships do not absolve a director of legal obligations. Misuse of information. Example, Insider trading under S78(1) of the Financial Markets Act. A director misusing inside information commits an offense even if it does not qualify as insider trading. Underscore. 6.4.4 Directors' Personal Financial Interests, S75, General Rule. Directors must disclose conflicts of interest where personal financial interests conflict with the company's interests. 6.4.4.1 Companies with multiple directors. Disclosure required if the director has a personal financial interest in a board matter, a related person has a financial interest. A personal interest arises after board consideration. Related persons. Individuals related if a. are married or live in a marriage-like relationship, are separated by 2 degrees of consanguinity or affinity. Juristic persons related if one directly or indirectly controls the other. One is a subsidiary of the other. A third party controls both. Disclosure requirements. Director must disclose the interest at the board meeting and 1. Leave the meeting after disclosure. 2. Not participate in deliberations. 3. Still count for quorum purposes. 4. Not be counted for resolution approval. 5. Not execute documents related to the matter unless directed. Failure to disclose may render board decisions invalid, unless ratified by shareholders, or declared valid by the courts. S75-8. Turquoise Rule vs. Section 75. Turquoise Rule. Third parties assume company internal formalities were followed. S75 Override. Non-disclosure invalidates board decisions, overriding the Turquoise Rule. Consequences of non-disclosure. Liability under S218(2). Any party can claim damages for losses suffered. Liability under S26. Shareholders can sue directors for fraud or gross negligence, unless ratified. Disclosure after board consideration. If a director or related person acquires an interest after board approval, they must promptly disclose it to the board or shareholders. Extended definition of director for S75 includes alternate directors, prescribed officers, board or audit committee members, even if not board members. Exceptions to S75 disclosure. Disclosure not required if the company has one director and one shareholder. The decision affects all directors equally. The decision relates to removing the director from office. Underscore. 6.4.4.2 Companies with a single director. No disclosure required if the sole director is also the sole shareholder. Disclosure required if the single director is not the sole shareholder. The agreement involves the director or a related person's financial interest. Approval must be obtained via ordinary shareholder resolution. Next page. 6.4.5 Liability of directors, SS 77 and 218(2) Common law liability. Directors may be personally liable for breaches of fiduciary duty. Personal liability can arise for losses incurred by third parties or the company. Directors must repay any secret profits made while acting as a director. Statutory liability, Companies Act, 2008, several provisions impose personal liability on directors. Section 77, Liability of directors and prescribed officers. Section 218(2), Civil actions. Section 29, Lifting the corporate veil, covered in Chapter 2. 6.4.5.1 Section 77, Liability of directors and prescribed officers. Applies to loss, damages, or costs sustained by the company, not third parties. Company may recover losses from a director if breach of fiduciary duty under common law, S75, no disclosure, or S76, breach of director's duties, breach of any provision of the Act, even if not listed in S77, breach of the company's Memorandum of Incorporation, MOI. Additional grounds for director liability. Acting on behalf of the company without proper authority. Knowingly carrying on business recklessly or fraudulently. Contravention of S22(1). Being party to an act or omission intended to defraud creditors, employees, or shareholders. Signing or authorizing false or misleading financial statements. Signing or authorizing a false prospectus or written statement regarding directorship consent. Director liability for failure to vote against specific actions. Liability arises for not opposing the following contraventions. Action by the director contravention. Issuing shares contravention of S36, unauthorized share issuance. Issuing securities inconsistent with S41, shareholder approval required. Granting of options granted for unauthorized shares, S36. Providing financial assistance, Non-director, contravention of S44 or moi. Providing financial assistance, director, contravention of S45 or moi. Approving a distribution, contravention of S46. Acquiring company shares, contravention of S46 or S48. Other provisions of Section 77. Joint and several liability, directors share responsibility with others liable for the same act. Time limit, claims must be brought within 3 years of the act/emission. Court relief, S77-9. Court may excuse a director from liability if the director acted honestly and reasonably. It would be fair to excuse the director given the circumstances. Preemptive relief, S77-10. A director anticipating a claim can apply for court relief. _ 6.4.5.2 Section 218(2), Civil Actions. Wording of S218(2). Any person who contravenes any provision of this Act is liable to any other person for any loss or damage suffered by that person as a result of that contravention. Scope. Covers all individuals, not just directors, who violate the Act. For example, shareholders, auditors. Directors may be held personally liable for monetary claims if their contravention caused loss. Not strict liability. Common law principles of delict still apply: fault, causation, foreseeability. Case study, Liamis Investment Holdings, RF, Limited v. Kirkinis. Facts. Shareholders sued directors for loss in share value, arguing violations of S22(1) and S76(3). Court's ruling. Rejected the claim. Shareholder loss due to decreased share value is reflective loss and not recoverable. Common law principles still apply, no indication that S218(2) overrides them. Legislative intent. If the legislature had intended to allow such claims, it would have done so explicitly. _ 6.4.6 Indemnification and Directors' Insurance, S78. Directors and former directors covered under indemnification rules. Restrictions on indemnification. A company cannot contract out of director liability for fiduciary breaches. Moi. Agreements, rules, or resolutions cannot relieve directors from liability. Company may advance expenses for directors' legal defense, unless moi states otherwise. Insurance. Company may take out indemnity insurance for directors' liability or expenses. Company cannot pay fines imposed on a director convicted of an offense. Limits on director indemnification. A company cannot indemnify a director for liability arising from acting on behalf of the company without authority, knowingly operating while insolvent, fraudulent acts or omissions, willful misconduct or breach of trust, fines imposed under national legislation. Restitution, S78-8. Company may claim restitution from a director for any improper indemnification payments. Next page. 6.5 Number of directors and consent. Minimum number of directors. Private and personal liability companies, at least 1 director. Public and non-profit companies, at least 3 directors. A person becomes a director by appointment or election as per the Companies Act, 2008 or moi. Holding an office, title, or designation that makes them an ex officio director. Delivering written consent to the company accepting the position. Section 6611 of the Companies Act, 2008. If a company does not meet the minimum director requirement, the board's authority and company actions remain valid. 6.6 Moi may vary certain provisions of the Companies Act, 2008. Some provisions on directors can be modified by the moi, while others cannot. Table 6.6, Moi vs. Companies Act, 2008 on directors. Provision Companies Act, 2008 Moi. Number of directors - private and personal liability companies, at least 1 director, S66-2. Public and non-profit companies, at least 3 directors, S66-2. Board actions remain valid even if the company lacks the required number of directors. Can increase the minimum number of directors. Cannot reduce the number below the Act's requirement. Cannot invalidate actions of a board acting without the required number of directors. Appointment of directors. Section 66(4)(b). Shareholders must elect at least 50% of directors and alternate directors. Moi can allow specific individuals to appoint or remove directors, but at least 50% must still be elected. Removal of directors. Section 71. A director can be removed by an ordinary resolution of shareholders, regardless of moi or company rules. Agreements between the company and director or shareholders. Moi cannot override shareholders' right to remove a director via an ordinary resolution. Ex officio directors Section 66 4A, 2, the MWA may allow the appointment of ex officio directors. The MWA can specify who will be an ex officio director. Alternate directors. The Act does not require alternate directors. The MWA can provide for their appointment or election. Remuneration of directors. No automatic right to remuneration. Section 66(9), a company may pay directors unless prohibited by the MWA. Directors' fees must be approved by a special resolution within the last 2 years. The MWA may allow remuneration but must still be approved by special resolution of shareholders. Term of office. Directors must be elected to serve for either indefinite term, fixed term as per the MWA. The MWA can specify term limits for directors. Ineligibility and disqualifications. See 6.7 below. The MWA may add extra disqualification criteria, but cannot override the Act's provisions. Qualifications not specified. The MWA may require minimum qualifications for directors. 6.7 Ineligible and disqualified persons. Applies to directors, alternate directors, prescribed officers, members of board committees and audit committees, even if not board members. Ineligible persons, absolute prohibition. Ineligible person. Reason. Companies Act Section. Juristic persons, companies, close corporations, and trusts. A company or trust cannot be a director. Section 69(7). Unemancipated minors or persons under legal disability. Minors, under 18, cannot be directors. Section 69(7)(b). Persons not meeting MWA requirements. MWA may impose additional ineligibility criteria. Section 69(7)(c). Case law, ex parte velx. Court questioned whether an emancipated minor could be a director. Disqualified persons. Court may grant exemption except in some cases. Disqualified person. Companies Act Section. Person prohibited by a court from being a director. Absolute disqualification. Section 69(8). A person declared delinquent by a court under Companies Act, 2008 or Close Corporations Act. Absolute disqualification. Section 69(8). A unrehabilitated insolvent court may allow appointment. Section 69(8)(b). A person prohibited by public regulation court may allow appointment. Section 69(8)(b). 2. Person removed from office of trust for dishonesty. Disqualification lasts 5 years from removal date or until sentence completion. Court may allow appointment. Section 69(8)(b). 3. Person convicted and imprisoned, without the option of a fine, for theft, fraud, forgery, perjury, or similar offenses. Disqualification lasts 5 years from sentence completion. Court may allow appointment. Section 69(8)(b). 4. Person disqualified in terms of a company's MWA. Disqualification per MWA applies. Next page. 6.8 Exemptions to director disqualifications. Section 69(11) of the Companies Act, 2008, grants courts discretion to exempt certain disqualified persons from appointment as a director. Eligible applicants for exemption: unrehabilitated insolvents, persons removed from an office of trust for dishonest misconduct, persons convicted of a crime involving dishonesty. Process: the applicant must make an ex parte application to the court. Requirements for exemption: if disqualified due to dishonest misconduct or a crime of dishonesty, the applicant must prove rehabilitation and that they can be trusted as a director. Case studies, applications for exemption. 1. Ex parte taob. Applicants convicted of bribery sought exemption after 1 year. Court denied the application, stating bribery and corruption pose serious risks, and too little time had elapsed to prove rehabilitation. 2. Ex parte baron. Applicant was a director convicted of fraud, mislabeling ostrich leather for export. Court considered factors affecting discretion. Type of offense: first-time conviction or repeat offense. Type of punishment: whether the company is public or private. Shareholders' attitude. Court noted greater leniency for private companies than public ones, as public company directors manage funds impacting many investors. 6.9 Application to declare a person delinquent or under probation. Section 162 of the Companies Act, 2008, allows courts to declare a person delinquent or place them under probation. Eligible applicants for such orders: 1. A company. 2. A shareholder. 3. A director. 4. A company secretary or prescribed officer. 5. A registered trade union representing employees. 6. Any other representative of company employees. 7. The Companies and Intellectual Property Commission, CIPC 8. The Takeover Regulation Panel. Consequences of delinquency and probation orders. A delinquent declaration, S-162-5A, F. Unconditional and subsists for life, or for at least 7 years if made under S-162-5C, F. Court may impose conditions such as remedial education, community service, compensation for affected persons. A probation order lasts up to 5 years. May include conditions such as supervision by a mentor, restriction to private company directorships. Grounds for delinquency and probation orders. Delinquency, S-162-5, may be declared if a director served as a director while ineligible or disqualified, violated a probation order, grossly abused their position, took personal advantage of company information, inflicted harm on the company through intent or gross negligence, committed fraudulent or reckless acts under S-77-3. Probation may be declared if a director acted inconsistently with director duties, supported oppressive or unfairly prejudicial decisions under S-163-1. Additional grounds for delinquency, S-162-5D, F, available to SIPC Takeover Regulation Panel. Director repeatedly received compliance notices for similar misconduct. Director twice convicted of offenses or subjected to penalties. Director held leadership in multiple companies/close corporations that were convicted of offenses or fined within 5 years. Purpose of Section 162. Not punitive, but protective of investors and those dealing with companies. Case studies, delinquency applications. 1. Kukama case. Application to declare Mr. L delinquent. Court found Mr. L allowed company funds to be paid into another account, failed to return fraudulent R39 million SARS claim, did not inform co-director of fraudulent transactions. Court ruled his conduct breached fiduciary duties and amounted to gross negligence, willful misconduct, and breach of trust. Delinquency order granted. 2. Guala case. Court ruled that gross misconduct, even if no company loss occurred, justifies delinquency orders. Recklessness equals serious misconduct that breaches shareholder trust. Purpose: protect investors and ensure competent company management. Next page. 6.10 Suspending and setting aside orders of delinquency. A person declared delinquent, except for a lifetime order, may apply to court to suspend a delinquency order and substitute it with probation, with or without conditions, after 3 years. Set aside the delinquency order after 2 years of probation. Court considerations for granting an order. Applicant must have satisfied any attached conditions. Court must be convinced of the applicant's rehabilitation and future fitness to serve as a director. 6.11 First directors of a company. Every incorporator is deemed a director until the required minimum number of directors is appointed. If the number of incorporators and appointed directors is below the minimum, the board must call a shareholders meeting within 40 business days after incorporation to elect additional directors. 6.12 Vacancies on the board. A director ceases to hold office in the following circumstances: end of a fixed-term contract as per the Memorandum of Incorporation, MOI, resignation, death, or incapacity preventing performance of director duties. Ex officio director ceases to hold a qualifying office, declared delinquent or placed on probation under conflicting conditions, becomes ineligible or disqualified, removed from office by shareholders' resolution, board resolution, court order. If the board removes a director, the vacancy only arises after the review period expires or the court grants an order. The director is suspended during the review period. 6.13 Filling of vacancies. Vacancies, except for ex officio directors, must be filled at the next annual general meeting, AGM, if required, within 6 months at a shareholders meeting or by a voting poll. If no directors remain or none are resident in South Africa, any shareholder with voting rights may convene a meeting to elect directors. Companies must file a notice with the Commission within 10 business days of a director's appointment or resignation. 6.14 Removal of directors. 6.14.1 Removal by shareholders. Directors can be removed by ordinary resolution at a shareholders meeting, regardless of the company's law or rules, agreements with the director or between shareholders. Case study: Kukama. A court declared Mr. L delinquent under S-162. The declaration automatically removed him as a director, making a separate removal order unnecessary. Procedure under S-71-2. Prior notice of the resolution must be given to the director. The director must have a reasonable opportunity to present their case. Removal cannot be done via round-robin resolution. Shareholders' agreements on director retention. Under the Companies Act, 1973, S. 220, companies could remove directors regardless of MWA provisions or agreements. Case, Amoils v. Fuel Transport, Proprietary, Limited. The court upheld the company's statutory right to remove a director. However, shareholders bound by contract to retain a director could not breach their agreement. Companies Act, 2008, now explicitly states that a director can be removed despite any contrary provisions in MWA, company rules, or agreements. 6.14.2 Removal by Board of Directors. A company with more than 2 directors may remove a director by board resolution if the director becomes incapacitated and unlikely to recover. The director is negligent or derelict in performing their duties. Director's right to challenge removal may apply to court for review within 20 business days. Court may confirm the removal or issue an alternative order. For companies with fewer than 3 directors, the company's tribunal may determine director eligibility, incapacity, or misconduct. Case study, Talisman Compressed Hair, Proprietary, Limited v. Dickman. A director/shareholder applied to the company's tribunal to remove another director for neglect and dereliction of duty. The court confirmed the tribunal's role in such cases. 6.14.3 Removal and breach of contract. Removal as a director may constitute breach of contract. The removed director may claim damages or compensation for loss of office under common law. 6.15 Board Committees and the Audit Committee. Board committees may be established and delegated authority unless the MWA states otherwise. King 4 Principles. Delegation must promote independent judgment and balance of power. Distinction between delegation and abdication. Board remains ultimately responsible. Liability remains with the board, even if duties are delegated. Composition of board committees. Non-directors may be members but cannot vote. Committees can consult experts and have full authority on delegated matters. The Minister of Trade and Industry may require companies to establish a social and ethics committee based on annual turnover, size of workforce, nature of activities. Mandatory Social and Ethics Committee. Regulations 43(1) and 92 require state-owned and listed companies to appoint a Social and Ethics Committee. Companies with a public interest score over 500, in 2 of the last 5 years, to establish the committee. Exceptions. If the parent company has a committee performing duties on behalf of subsidiaries. If the company's tribunal grants an exemption. Audit Committee. Not a board committee, appointed by shareholders. Regulated by the Companies Act, 2008. Duties. Review financial statements and report on governance. Comment on financial statements in the annual report. Other committees may include Nomination Committee, Remuneration Committee, Risk Committee, often combined with Audit Committee as Audit and Risk Committee. Next page. 6.16 King 4 Proposals on Board Committees. King 4 recommends establishing board committees to assist directors by focusing on key areas. The relevance of specific committees depends on industry and company-specific issues. Responsibilities of board committees. Table 6.7, Remuneration Committee. Recommends remuneration packages for executive directors. Suggests fees for non-executive directors. Evaluates performance in key areas contributing to company success. Nomination Committee. Assists in transparent board and company secretary appointments. Reviews board composition, skills, experience, demographics, and diversity. Evaluates board committees and individual director contributions. Risk Management Committee. Reviews risk management processes and significant company risks. Audit Committee, not a board committee but appointed by shareholders as per Section 94 of the Companies Act, 2008, discussed in Chapter 13. King 4 Requirements for board committees. Committees must have formal terms of reference, approved and reviewed annually by the board. Terms of reference must include committee composition and appointment process for non-board members, roles, responsibilities, and decision-making authority, committee tenure, reporting procedures, and access to resources, meeting procedures and performance evaluation criteria. Proposed Social and Ethics Committee would perform functions prescribed by the Minister of Trade and Industry. 6.17 Board Meetings. A director authorized by the board may call a meeting at any time. Meetings must be called if required by the company's MWA, requested by at least 25% of directors, if the board has 12 or more members, requested by at least 2 directors, if the board has fewer than 12 members. Round-robin resolutions, Section 74, Companies Act, 2008. Board decisions can be made without a formal meeting through written consent by a majority of directors. Each director must receive notice of the matter to be decided. Such resolutions hold the same effect as decisions made at a board meeting. Case study, CDH Invest NV. A round-robin resolution attempted to amend the company's MWA, increasing authorized shares from 1,000 to 1 million. Court ruling. Section 74 allows round-robin resolutions only if all directors receive proper notice. Notice must include the subject matter to ensure informed decision-making. Directors in this case failed to provide reasons for the resolution. Round-robin resolution declared invalid due to lack of proper notice. 6.17.1 Electronic communications. Board meetings can be conducted via electronic communication, for example, video conferencing. Directors can participate remotely if the system allows concurrent communication without an intermediary. 6.17.2 Notice of board meetings. Notice form and periods determined by the board but must comply with the company's MWA rules. No meeting can be convened without notifying all directors. If all directors acknowledge receipt of the notice or waive the requirement, the meeting may proceed even if notice was defective. 6.17.3 Quorum at board meetings. A majority of board members must be present for a vote to be held. 6.17.4 Voting at board meetings. Each director has 1 vote. A majority of votes is needed to approve a resolution. In a tie, the chair may cast a deciding vote if they did not initially vote. If no deciding vote is cast, the matter fails. 6.17.5 Minutes and resolutions of board meetings. Companies must keep minutes of all board and committee meetings. Minutes must include declarations by directors. Resolutions adopted. Resolutions must be dated and sequentially numbered. Resolutions take effect from the date specified unless stated otherwise. Signed minutes and resolutions by the chair serve as evidence of proceedings.